Hello, welcome to this conference. This is the second conference of our network, the LAwTTIP network, which is a program financed by the Commission of the European Union, the Jean Monnet Action. Our network is composed of 3 universities, the Rennes, we already have had a very good conference there, Bologna, and the next conference will be in London at the King's College. In our network, we should have studied the TTIP when we proposed the subject. We were approved with this title, but of course the TTIP now is dead, and we are studying a broader subject, which is new generation agreements, but we keep the focus, respectively, on fundamental rights. This is the task of Bologna, on the institutional and competence issues, which is the Rennes subject, and on the judicial issues, that is the topic which is developed by the Kings. Thank you very much to our speaker of today. I leave the floor, first of all, to our Vice Rector for the Research of the University of Bologna, Antonino Rotolo.
Thank you very much. Very happy to open this conference, also on behalf of the Rector, Professor Albertini. I mean, the topic of the conference is very interesting to me. It's very challenging for 2 reasons. First, because you are talking about values and rights in trade. First challenge. The second challenge, relationship between US and European Union. If combined, the thing is really challenging. I will not say anything regarding the second point. Well, that's, for obvious reasons. I will say something regarding the first point, in values and rights in trade. In the perspective of research, right? I'm Vice Rector for Research. I'm also a professor in law school, so, but in general. But of course, a well-established view is that the liberalization of trade is a way for ensuring and facilitating the promotion of values and rights, right? Like, public health, consumer safety, and stuff like that, right? And that's quite well established in the literature. And but of course, if the values emerge from free trade, of course, this perspective doesn't tell us the whole story, right? Because of course, values are not necessarily emerging from the market as a whole, right? The market is broader than trade, includes other mechanisms, and in fact, this is the issue, right? And in the conference, I watched had a look in the program, right? You basically deal with all issues, right? IPR, data protection, which is very hot nowadays, food safety, labor standards. All these are discussed in the conference, and there are also other topics that are discussed in the conference. But I would say there is a broader view you could offer, and which I think very interesting, and I can propose the University of Bologna view, which is the United Nations Sustainable Development Goals, right? Of course, this is the framework for values, by the way, in which the University of Bologna is working on. So I can tell you what we do as university. Since 2016, we are reporting our activities, and we are promoting activities in terms of research and teaching programs within the framework of the development goals of the United Nations, right? And this is also in the European agenda, right? Because, as you, of course, the European Commission is focusing on this, for example, for promoting innovation and research in Europe, in FP9, for example. So I would say that I'm very sympathetic with what we are doing here, talking about values in the perspective of European Union. Of course, you are focused on trade, but I would say would be great to see a broader view which goes beyond trade. This is a perspective of the Vice Rector for Research. So have a fruitful conference, and thank you very much for your attention.
Thank you very much, Nino. The focus on trade is dictated by the fact that the money of the Commission finances this project. But believe me, we are studying human rights, fundamental rights and value in the EU in general, not only in the framework of this research. So we Okay, now the director of the Department of Legal Studies, Michele Caianiello. Thank you to be here. You have the floor.
Thank you, and good afternoon to all of you. I'm pleased and honored to be here to inaugurate this session of work of today. Actually, I'm deputy head of my department, but I'll be head of the department if nothing exceptional happens the next month, at the beginning of the next month. So I'm just the elected head of the department for now. I'm pleased to be here because the group of research of the scholars in European Union always open a new path for the whole department of ours regarding internationalization and opening the researches with other countries and other cultures. So again, they are in the front line in developing new methods, and I'm here pleased to express first of all my support to the group of European Union of Research here in Bologna, and thanking them for the effort they produce in these years to develop international researches. But also to thank the colleague of the other universities and all of you for being here. Internationalization of research and teaching is at the core of the development of our department. And I'm sure that the scholars of European Union will be at the center of the developing of our department hereinafter. Well, I'm not an expert on trade, actually, I must admit, because I'm a criminal lawyer from my cultural background. I know something, but not much, about rights and fundamental rights. But I'm challenged and charmed by the subject of this conference, because it mixes together the problem of trade between two continents and two very different realities on one side, but also on rights, values, and this is something I understand better from my criminal law point of view. It seems to me that the importance of fundamental rights in European Union has been increasing, perhaps too much, in the last decades. And now we are in a sort of an uncertain moment, I apologize for my English, in which we want to promote our fundamental rights and values in the relationship with other external entities, but on the other side, the immense development of fundamental rights is creating tension inside the European Union. So the first problem is that we are managing something that is not so easy to handle. And as Italians, we experienced this tension on two issues which relates with criminal law. On one side, the Tarico saga started in 2015 and ended perhaps last April 10th before our Constitutional Court. But I'm not sure that it's going to end. And on the other side, on the double punishment, the way in which we melt together and harmonize the criminal punishment of certain misbehaviors and the administrative or fiscal punishment. Well, the problem of handling fundamental rights is a problem of constitutional identity, of having a common meaning and approach to fundamental rights, but also of national sovereignty and in the end, a problem of power. So we need to treat very carefully this matter, which is at the same time mostly important, but also could be the cause of disgregation inside the European Union. We have a double or triple task, we might say, on this side, to seek uniformity internally. It means at the internal of the European Union, but on the other side, the European Union has the ambition to promote its values in international relations, and also in trade, defending the European Union interests, and also at the same time the national economic and social interests. So we are facing a challenge which is crucial for the European Union prosperity, but probably also for the European Union survival in a way. Either we will be able to create a common language and a shared interpretation of fundamental rights, but also we will agree together on who's got the last word about fundamental rights. Or we risk to collapse. So is even more true today than ever for the European Union, the old saying, real for the private companies, up or out. Will we be able to develop our values and to propose them in a united way, or we risk to lose the challenge we are facing? I really hope that this event and all the other that will follow will help us to find some answer for the future. And thank you and have a good work.
Thank you very much, Michele. Isabelle Bosse-Platière is a member of our network of the University of Rennes, and I ask her to also to introduce the network and the work in general.
Okay, good afternoon to all of you. I've been asked by Lucia, Rossi, and Federico to say a few words to welcome you on behalf of the LAwTTIP network. As Lucia Rossi mentioned just before, our program is a Jean Monnet network. And I don't know if you know what LAwTTIP means. It means legal ambiguities withstanding TTIP. It is a partnership between, it builds a partnership between three universities, University of Bologna, University of Rennes, and the King's College of London. And the purpose of our project is to provide a legal analysis of the TTIP and beyond, because TTIP no longer exists, beyond of all EU free trade agreements, as it seems that this new generation of external agreement of the European Union reveals a lot of issues for EU external action and offer new perspectives for the affirmation of the European Union on international stage. We have a lot of activities scheduled over the 3 years covered by the program in each university. Some of them involved, and I say that because I see that in the audience there are a lot of students, so some of our activities involve PhD students and master students. And for example, the doctoral summer school or the young researchers workshop we organized Bologna organized last year, and 2 other workshops, a young researchers workshop will take place, one in London next year and one in Rennes. The program has also a strong teaching dimension. You can find a lot of information on what we are doing, so virtual lectures, teaching toolkits, materials, working papers about the TTIP and more generally about the free trade agreements of the EU. You can find them on our website, so LAwTTIP.eu. Website which is regularly updated with great efficiency by Federico and the Bologna team. But the main event each year is of the program. The main event is the joint conference. As Lucia Rossi said, last year we had the first conference in Rennes. And we concentrated on institutional and procedural dimension on free trade agreements. And a book shall be published by the end of the year, coming from this conference. And now we are met up for the second conference here in Bologna. And we come to the substantive aspect of the topic, so right, trade, and values. This is, as the Vice Rector said, this is a very challenging topic, as we all know that since the entry into force of the Treaty of Lisbon, the European Union is considering itself as a union of values, not only internally, but also in its external relations. It is clearly provided for by Article 21 of the TEU. But the main issues and the main question is to know what are the issues? For example, is sustainable development and values or not? So what are these values? And the question is how they can be conciliated or articulated with the interest of the EU, because Article 21 refers also to the interest of the Union. And when we speak about trade, then the question of interest is not very far from it. So this is a lot of very interesting and challenging topics, exciting topics we will discuss today and tomorrow. So I would like to very warmly and sincerely thank Lucia and Federico to have organized this conference and to have settled a very exciting program. And I wish you a very pleasant conference. Thank you.
Thank you very much, Isabelle. Thank you to our panelists. May I call our new panelists, Professor Casolari, Professor Paul James Cardwell, Professor Thomas Cottier, Professor Cécile Rapoport. Unfortunately, Inge Govere, due to health reason, is not able to join today. It's a pity because ACMEA is the case, the most important case in the external relation at the moment, and so I invite the other speakers to speak of ACMEA if they want, because Inge Govere unfortunately is not here. And also let me use this time for thanking very much Federico Casolari, who sits here behind me, because Federico is really the backbone of our network, and not only helped a lot in planning and organizing this conference, but more in general, all the works of this network are possible thanks to his big work. And when I leave for the Court of Justice next October, Federico will take my place and will be the coordinator. The Commission has already accepted that, so there will be no vacuum. Are we ready? So thank you very much to our panelists. I will just very briefly introduce them. Our first panelist, Federico Casolari. Federico is a professor here in Bologna, associate professor of European Union law, but he teaches other courses such as global and supranational law, and also EU constitutional law. Federico will deliver just some introductory remarks. You have the floor.
Thank you very much, Chair. Thank you also for your kind words. And welcome everybody to this conference. Allow me just to say some words very briefly on the idea of this second joint conference, which constitutes a second, let's say, reflecting moment for our network and for all the partners on the research topics. So today and tomorrow we would like to launch a general assessment and reflection on the interplay, as it has been already anticipated, between the EU trade cooperation and the EU fundamental rights and values, that is, the EU constitutional identity in one expression. as you probably noticed in the title of this conference, a question is contained that it is related to the major focus of interventions and the contributions of the speakers. So the speakers will focus their attention on this interplay in the light of the contractual relations between the EU and US. But of course, the perspective is larger, and so also other contractual relations of the European Union with other third countries, and so other free trade agreements will be taken into consideration. And also the member states' dimension, the member states' role will be considered in this respect, and so also the relations that member states have established with third countries. So we cannot ignore the other elements of practice that are emerging in this area, and which is also related to the activity of the member states. Professor Bosse-Platière has anticipated that today, after the entry into force of the Lisbon Treaty, it is clear that the dimension concerning the protection of fundamental rights, fundamental values of the European Union is completely enshrined in primary law as far as the external dimension of the Union is concerned. According to Article 21, the European Union in its relation with third countries and with other international organizations shall ensure the full respect of its constitutional identities, of its values and fundamental rights. So apparently this, let's say, interplay should be clear and well established. And also the European Commission recently in its strategic document, EU Trade for All, has clearly made it clear that the value dimension of protection of fundamental rights should represent one of the major elements to be taken into consideration when the Union is cooperating with other countries in trade matters. But this said, it is clear that if we look at the practice, of course, that the concrete implementation of the contractual relations of the European Union, and so the concrete establishment of EU trade cooperation reveals problems in terms of coherence and let's say, proper interplay between trade interests and fundamental values, fundamental rights. This is due, on the one side, to the different level of protection of fundamental rights, which are recognized by the different relevant contracting parties. Maybe sufficient to mention the recent Oxford Analytica affair, just to give you an example of different, let's say, understanding of the level of protection of relevant rights. And this is also related to a different understanding of the values that are relevant in trade cooperation. So as it has been recalled some weeks ago in this room by Professor Joseph Weiler, also some value fault lines may be, let's say, identified, separating the European Union from other countries, fault lines that are, let's say, moving and are likely to cause clashes among values, and also at international level, of course, and so that need solution in order to be prevented, to be solved. So against this general background, the conference program has been organized as it follows. The first section of our works should, let's say, set the scene and introduce the general legal framework which is relevant when it comes to protect the EU fundamental values and the EU fundamental rights in trade cooperation. So we will consider the EU tools and the EU mechanisms, but also international mechanisms that may be put in place. For instance, the possibility to have a regulatory cooperation between the Union and other international subjects in order to fix common standards on fundamental rights protection. And then we will also consider the national dimension, and so let's say possible problems related to possible clashes between national values and rights, or national understandings of these rights, and the agreements the Union is entering into at international level. So once fixed this general framework, this general picture, we will have two sessions of our walks devoted to sectoral themes, to sectoral dimensions, so where the speakers will analyze the concrete interplay between the cooperation of the Union that has put in place with the other subjects and the rights and the values at stake. And then the final session tomorrow will try to, let's say, put all the debate into perspective, trying to also considering in a de lege ferenda perspective possible solutions for the problems that have been highlighted during our conference. And the conference, of course, will be concluded by some interim concluding remarks that Professor Marc Marescot kindly accepted to formulate in the light of our previous discussion. So again, I thank you very much for being here. Thank you the speakers and the chairs for having accepted our invitation. I wish you a good conference and of course a lovely stay here in Bologna. Thank you very much.
Thank you very much, Federico. Now, our next speaker, Professor Paul James Cardwell, who comes from the University of Strathclyde, and he also is an honorary fellow of the Europe Institute in Edinburgh, and was visiting professors in some universities such as Sciences Po at Paris and University of Zagreb. And he's going to speak of values. Is the EU a value-led international actor? Thank you very much to be here, and you have the floor.
Thank you. Grazie. Thank you very much for the kind invitation to be here, particularly to Federico, to invite me. As you heard, and my academic background is not so much in trade as it is in external relations more generally, and particularly the common foreign and security policy, and some aspects of migration and neighbourhood policy. So TTIP is beyond my usual area of specialisation, and my experience in trade and the European Union's external trade is less with the United States, but completely the other direction in Japan. And I spent some time working for the European Commission at the delegation in Tokyo, which when I was writing about it some 15, 20 years ago, nobody cared about, but now sort of has come back into fashion because of the potential agreement, or the agreement with the EU and Japan, which brings up a whole set of other issues about values and so on as well. So what I'm going to talk on today is, as Federico said, more generally about what can we say about the EU as a values-led international actor, and going beyond the remit of trade, how do we see these values being expressed in what the European Union does, but also importantly what it says, and what it says it does, and what it says it would like to do, and what it doesn't say but does anyway. So what we find here is really a differentiated pattern of values across the European Union, which I'm going to, and its external action, which I'm going to try to explore in some detail. My starting point is looking at the global strategy of the EU, which, as you all know, was issued in 2016. There's been a report about its progress so far, and a new one is expected. Within that global strategy, we find the following. The EU's credibility hinges on our unity, on our many achievements, our enduring power of attraction, the effectiveness and consistency of our policies, and adherence to our values. So we find very much that the idea of values is at the core of what the EU does, and I'll come back to what it says in the treaty shortly. But here we find head-on the attempt to confront not only what are perceived as the EU's weaknesses as an international actor, including and not only limited to trade, the criticism including the fact that it's seen as incoherent, cumbersome, and lacking in priorities and focus, but to imbue those also with values. Now, although the global strategy is, we can't really call it a trade strategy, it goes much beyond that. In fact, trade, we might think, plays a very limited part of that. But actually, when you look at the strategy in more detail, we find that trade is mentioned really quite a lot, 26 times if you want to do a search and find. And by an amazing coincidence, the word values also appears 26 times. I'm sure there's no link, but it was quite nice to have as an anecdote between the two. And so we find constantly throughout this strategy the ideas, the values, without, as we might expect, a strict interpretation of what those actually mean. But we also find some distinction here as well. So when there is mention of TTIP and also the CETA agreement with Canada, we find the references there are to shared values rather than the EU's values. So here what I want to look at is to question the interconnectedness of the values the EU seeks to promote, given that these can be seen to be mutually contradictory for a polity which is not only focused on trade, but seeks to be a meaningful actor in many other areas too. The way I've tried to structure it is by looking at this differentiation of values, both in terms of how they apply in different circumstances, whether those be in the internal sphere of governance or the external sphere, but also when dealing with different issues, whether those be trade, migration, development, environment, and so on. Although that's not a new observation, the fact that we can see these differentiated values within the post-Lisbon era, where we have this treaty expression, which I'll come on to in a moment, tells us something about the kind of actor the EU purports to be, or aspires to be, and the way in which it carries out its business in practice. So in terms of the values, well, in a sense, it's obvious that the EU acts according to values because it's an actor, and actors have values, whether or not they express them and whether or not their actions match up to what their words are. As we've already heard, the difference with the European Union is that there is an explicit mention of values within the treaty. Article 2 says the Union is founded, Article 2 of the Treaty on the European Union, the Union is founded on the values of respect for human dignity, freedom, democracy, equality, the rule of law, and respect for human rights, including the rights of minorities. Now, we might say that in its constitutional foundations, then, that sets the EU apart. And we do find in national constitutions as well, not only expressions, of course, of values, but also how they structure external relations. Joris Larik has written a piece, a chapter on this, and looking at national constitutions and how they structure into the international relations of that country, of course, which is relatively common amongst EU countries. But the difference really with the European Union is the nature of which these values are designed to structure not just international or the common foreign security policy and so on, but also international trade and so on as well. Article 21 has already been mentioned, and the specific mention of promoting our values, the values of the European Union, with neighbouring countries. So we also already find there a differentiation between what are shared values and what are our values to promote. And that also then justifies questioning what these values are and how they operate, because the European Union can therefore be measured against the values that it says itself it will promote. And we still very much have this dominant idea within EU discourse of the type of actor the EU says that it is or that it wants to be, separate from traditional notions of what the member states does. And we find this, of course, in the literature going back to the 1970s, where we had civilian power Europe, a different kind of actor to a military-focused actor. And then, of course, normative power Europe, as Ian Manners has been writing about since the early 2000s, which has provided a great basis for scholars to investigate whether the EU is a normative power actor and what this actually means. And I think there's still an adherence to this idea of the European Union being somehow different, even if we see things like military cooperation, defence procurement and so on, which means that this distinction that was made back in the 70s is no longer as accurate as it once was. But what is interesting to have seen how it's evolved over time is the separateness of the EU as an autonomous actor. It's not something which is merely the product of how the member states are acting together. And we see this particularly, of course, in trade. But there are still lots and lots of open questions, which some of which we will cover over the next couple of days in this conference, but others which will remain open. Firstly, of course, whether values, we talk about them in a very positive sense. We talk them about the things which everyone can agree on, in theory, the protection of human rights and the rule of law and so on. But what about values which might not be as nice, in inverted commas? What about if one of the values could be excluding those who don't fit or perceive to fit within our values, as we see in aspects of migration policy and so on? So the emergence of the values is dynamic, and the values that are listed in Article 2 that I mentioned do not tell us very much about the evolving nature of the EU's economic values, which is, of course, paramount in terms of the type of trade agreements that the EU has or which it seeks. Neither can an attachment simply to the treaty tells us about the evolving nature and the relationship between those of the values of the member states. It's assumed that these are common values. They might be interpreted very differently, but what happens when you have expressions of values which appear to be at odds with what the treaty says? So I'm thinking here of Viktor Orban's vision of an illiberal democracy. Does this mean that the EU can no longer be said to have a common vision of what democracy is, at least on some level? At what point do new values emerge if they have support of certainly several member states, or at least trends within that? So transmitting these values from the national level to the European level is perhaps less important in some areas where the Commission, as an actor, has its own vision of things and has managed to transmit these values or transmit certain values the other way. But nevertheless, it's something that we can never regard as being a fixed point. So, firstly, before moving on to the differences in trade and other policies, it's worth questioning how these values then operate within the internal and the external spheres and the meeting points where we can see potential conflict between them, or at least inconsistencies. We know that the European Union is set apart from looking at nation states in the fact that it is an integration project. It's about breaking down borders, which is a value in itself. But when projecting that to the external, it's not the case that the EU simply is to break down borders whenever we find it, whether it's in trade or other terms. We find that there are other issues at play there, particularly, for example, relating to the environment, which explains resistance to things like GMO crops and so on as well. Similarly, we find it in terms of movement of peoples as well. The EU has placed great emphasis on the lack of legal and physical barriers within the space of the European Union, but this is not the case when you talk about beyond the borders. Similarly, we find it in what's become really the hallmark of one of what's become the hallmark, if you like, of the common foreign security policy in recent years, which is the imposition of restrictive measures or sanctions on third countries. We find something in the region of 30 sanctions regimes towards third countries, but we find much greater reticence to apply those same values in situations within the European Union when there's, let's say, unfriendly government in power, and previous experience of doing that have been less than successful. And to go back to what the values of the treaty, and again to say that, well, the protection of rights and so on, they tell us something about how the EU can act as an international economic actor, but only so far. Here we expect perhaps the nature of trade liberalisation, as we've seen within the EU, to be expanded, but we don't always find this has been the case. And here the institutional aspects of the way in which the European Union works is particularly important, and particularly, as will be familiar to many of us, the increase in powers of the European Parliament has afforded an opportunity for opposition, particularly to things like the TTIP. And the criticism, therefore, that the favouring of values relates to economic ones rather than those which are actually listed in the treaties. And I do wonder whether the changes in the very nature of the European Union, which also set it apart from that of a member state, is that the European Union itself has changed. It has enlarged, and that brings in any number of different views on where it should evolve in the future. And perhaps when we look back at periods such as the late 1980s, where we can perhaps see a balancing of values under the Delors programme, where you managed to at least in the internal sphere, balance the free market liberalisation associated with Thatcher, where concerns about social Europe and balancing these different values, and whether that would be the same in the future. We see multiple examples, the Viking Laval saga, for example, about these different concepts of what Europe should be and where it's going, being played out within the institutions, which necessarily then have an effect in the external sphere. I could point out something about Brexit and break my rule about not talking about Brexit for 7 minutes, but it's certainly instructive in terms of, how do you surmise what the European Union is, and in a sense, and this is reflected in the values, it tries to be all things to all people all the time, and that's not always possible. Moving to the external sphere and the distinction between trade and other policies, again, here I would put focus on the common foreign and security policy, because it is designed to be, and it says in the treaty, the main way of the European Union's engagement in the world, particularly with areas which are not singly defined as economic. And one useful way of seeing how these values are expressed are in terms of what happens under the common foreign and security policy. One useful way of doing this is looking at the declarations. So not really legal in the sense of legislation as we're familiar looking at it, but in rather non-binding forms, which nevertheless give us an insight into the thinking of the institutions. I've looked at declarations over a 12-year period and analysed what they actually say and which of the values of the European Union they ascribe to. And it won't be a surprise to know that the most common values expressed in declarations are strongly related to democracy and human rights. They stand out in terms of the declarations which are issued, and these are declarations which are applied to a third country. For example, the European Union and its member states condemn the recent violence in this country, or does not, or criticises an election happening in a third country, or the use of the death penalty, whether that is something that's actually being used or something that's being abolished. Both of these result in declarations. Now, what's of course interesting there, and which we can see then reflected in the European Union as a whole, and this is why I say that it's an interesting sort of way in, is that we find these declarations which don't have particular force. They might have diplomatic or political force, but often nothing beyond that. Is that these are also differentiated. They're differentiated in terms of the subject matter, but they're also differentiated in terms of where they apply. So the death penalty is an example which has been used quite a lot in terms of how the EU's values, because it is one that's very easily identifiable. You can't have the death penalty if you're a European Union member state. How does this apply in the external? Well, we find that when, not on every occasion that the death penalty is used in a third state, but in certain states, it results in multiple declarations. This is particularly the case for Iran, and second on the list, perhaps more surprisingly, is the United States. On the other hand, we never find declarations issued for the use of death penalty in other states which use it a lot, namely China and Saudi Arabia. So here we find again a differentiation between the use, which is a way into seeing how then these values play out, whether it's protecting fundamental rights or protecting the environment and so on, also within things like trade agreements, depending on whether it's sought. And I think that's an interesting point of comparison then between TTIP, for example, or CETA, Japan, and other areas, and particularly with, say, developing countries. Now, to bring this together, what we find then is that, in a sense, talking about values, or values themselves are, within the treaty structure, are their own worst enemy. They are there, so it invites us to talk about them and invites us to measure what the European Union does. And we can find ourselves very easily disappointed because we look perhaps at one set of values which might be contradictory to other sets of values. And in some ways, they can be regarded as being almost an overload within the EU's constitutional system, even before the Treaty of Lisbon came about. So, can we say that the EU is led by values? Well, yes, we can, but these are highly differentiated, not only between the rhetoric and what actually happens, but also between which sphere we're about, which institutions are dominant, and whether we're talking about the internal or the external sphere. There's no easy way to map them on precisely. So, almost in this respect, and contrary to one of the themes that I've been talking about the European Union being different, the EU is no different really to what a member state might be or a nation state might be, which also you would expect to act according to different values and act differently perhaps than the kind of actor that they purport to be. And I think that TTIP is a fascinating case study of this because it not only demonstrates the tensions in terms of what the EU is doing or trying to do in the external sphere, but also how it was selling those as values within the internal sphere as well. Perhaps it's an example which is specific because of there's always going to be suspicion around a deal with the United States because we know more about the United States than we would do with other agreements that have taken place. For example, what springs to mind would be the one with Korea, and so this has put TTIP more in the spotlight, about generated more opposition to it than might have been the case, as I say, if it was with another state. Trying to bring the values together is a task which the Commission has tried. There's the Commission's 2015 paper, Trade for All, towards a more responsible trade and investment policy. But again, the risk is here that values are written or enunciated in terms of treaty obligations and adherence to them, but what actually happens in the field may be somewhat different. So I think the search for values will go on as long as the search for finding whether the EU is a coherent actor or not, which means that we can have plenty of opportunities, I think, in the future for more conferences on whether the EU and its values play out and how, of course, they evolve over time. Thank you.
Thank you very much indeed for this very clear and realistic presentation. We have now Professor Thomas Cottier speaking about the future of regulatory cooperation. Thomas Cottier is Emeritus Professor at the University of Bern, but he is the former Managing Director of the World Trade Institute and also professor at Professor of European International Economic Law. I think he has a presentation PowerPoint. Okay, so maybe we need to switch the light a little bit off. Okay, thank you very much.
Good afternoon, and thank you very much for this
invitation to speak on perhaps the youngest field of law, certainly in international law, at one of the oldest European universities where at the time the LAwTTIP prepared the European codification movement here. In this time of trade wars between the US and China, people tend to think that we're all back on tariffs, imposing surcharge tariffs on steel and aluminum, threatening tariffs on other areas, gets us back to the old days of trade policy. But if you look a bit closer, actually what is behind these tariff increases threatened by the US administration are regulatory issues, in particular the allegation that the Chinese are stealing intellectual property rights. Now, whatever that means, we don't really know. It may be simply a problem of national treatment, that domestic firms are treated more favorably than foreign firms, but it could also be a matter reaching far into competition policy where there are inconsistencies in perception on licensing. We don't know. We will see. The point is, this is a regulatory affair here. And what I'd like to do today is to show you how trade policy moved from classical free trade deregulation, which means to eliminate and reduce tariffs, into a highly complex regulatory field. This is the chart showing you the tariff reductions since World War II. This was informed by very high tariffs in the interwar period, which ran up to 50%. And the GATT was motivated to bring these tariffs down, and that was done very successfully over 50 years. On average, we have 4% industry tariffs, not counting agriculture here, of course, here. But with this reduction of tariffs and the nature of the beast started to change. We still talk about free trade agreements, and people assume that free trade agreements means to deregulate. In fact, it's a wrong term today. What we are doing today is we are actually re-regulating. We're trying to converge, we're trying to harmonize, we're trying to eliminate and reduce trade barriers by harmonizing legal orders with each other. And that is a much more complicated matter than simply eliminating taxes and tariffs here. And this is what you see on the right side on this slide here. It's about re-regulation, which of course poses a lot of challenges in terms of our decision-making processes, about our legislation, about also relations with third countries, because there are very tremendous spillover effects which we don't have in the field of classical tariff policy here. So what I think today, it is better to talk about trade regulation than to talk about free trade. The goal is still to facilitate international trade, but it is not free trade. It's a wrong perception, and we have to be very careful with the notion of free trade, in particular after financial crisis, where people feel that deregulating things is very risky and will lead to instability, and that's why there is an aversion against free trade, the way it's still perceived. But in fact, what we're doing is something different. We are today in the second and the third generation of trade barriers. This is just a history of it here. And the most recent one is dealing with services, which is essentially domestic affairs. We deal with intellectual property rights. The TRIPS agreement, I mentioned, the Chinese problem just by way of introduction. We deal with agricultural domestic support levels, food standards, etc. This is essentially all about domestic affairs, and we deal with them on the international level here. So things have become much more complicated in trade policy than they used to be at the time after World War II. And one of the most important challenges we face, which also relates very much to your topic on values here, are the so-called PPMs. This is essentially relying upon production process methods in distinguishing the treatment of different products. For example, can you distinguish a football stitched by children in a foreign country as opposed to a football stitched by machines here? Can we treat them differently? Can we link PPMs to human rights, to labor standards, to the ban of child labor here? And these are all issues which affect issues of sovereignty and are highly controversial. They affect different perceptions of values here. If you look at the agendas your generation, I'm talking here that the students will face when they negotiate for their countries in the future, this is all about regulatory affairs here. I don't have the time to go through these different issues here, but you can see that they very strongly relate to domestic policies and how to coordinate them with each other here. I'm just using digital trade. I know people reading the papers today are going through the Facebook hearings at the Senate may think this is a new topic coming up. In fact, this has been one of the major items on the US agenda for revising NAFTA. So even the US, with this current administration, is interested to pursue certain matters in the field of international trade agreements relating to regulation. And I think the Facebook hearings will reinforce this also with respect to relations to the European Union. Data protection for a long time was a big issue because the Europeans stressed the values of personality protection. The US neglected it coming from September 11th, but there is a convergence and the US seems to align to EU legislation in the future, and that will improve also the possibilities for international agreements here. Another point I really need to mention here is that this removal of tariffs, but the interfacing of different regulatory standards has allowed industries to operate in global value chains and in a very substantial division of labor. I don't know whether you're aware that more than 60% of all trade is trading components. Most goods go back and forth borders before they actually reach a consumer and their final stage. And this is what the structure is today. And you may see that manufacturing is often located in countries where labor costs are lowest, and then they are sent back, and the value chain will increase again when they are sold on developed markets here. And one of the interesting questions will be whether these extensive global value chains will be broken by the US trade policy seeking to repatriate jobs. Now, but when you operate these extensive global value chains, you see that there is a need for interfacing different standards. You all know this example here with the adapters when you travel around here. This is a good example where standards have not been harmonized to a large extent. It's not really a big issue, but if you go into other areas like health, pharmaceuticals, or car technology, etc., you see that it's quite costly to keep things unharmonized. Other areas are fully harmonized. If we talk about communication, technical standards on communication, whether it's air aviation, or whether it's telecommunication, they operate on fully harmonized standards. So we have a full panoply of differences. And this is a very interesting chart written by the OECD, where you can see the different approaches to regulatory harmonization and approachment here, from starting off from regulatory dialogues, exchanging information, all the way up to full economic integration. And of course, within the European Union, you're operating on the upper level of this here, usually using mutual recognition and then full economic integration. But in relation to third countries and on the international law level, we are much less advanced. And the question is, how far can and should this be taken here? The European experience, of course, in harmonization goes back to the experience of federalism in many countries and multi-level governance. That's a classical issue in public law. It's also inherent to devolution. I think in countries like Italy who strengthened the role of provinces, and other countries as well. And of course, you're familiar with the approaches used in the EU regulatory cooperation and approximation. Now, this is shown to be a very, very difficult and time-consuming process. It's usually 2 steps forward and 1 step back. But over time, I think within the European Union, using these approaches on that slide here have helped to bring about a substantial amount of regulatory harmonization in trade-related fields here. Now, when we talk about these behind-the-border issues, which are the regulatory issues, we may ask, how do they relate to preferential trade agreements here? And it's interesting to observe that most of the preferential trade agreements also concluded by the European Union essentially do rely on regulatory affairs on the basis of the WTO. And I'd like to inject here simply what are the values of the WTO, because we're talking about values. It's essentially about non-discrimination. This is an emanation of equality, a very fundamental one. And linked to that is the principle to seek equal opportunities, equal conditions of competition and equal opportunities here. And then there is a very strong commitment to the rule of law with the strong dispute settlement system, and there is a commitment to transparency. These are essentially the values in addition to the respect for non-trade concerns here. And essentially all these preferential trade agreements, they do build upon that. If you go into the most modern one like CETA with Canada, it's essentially relying upon WTO law here. It's different in the TTIP draft here, and that's why TTIP is and remains a very, very important project here, and I congratulate you that you deal with this in this venture here. I think it's the most important effort to address the regulatory convergence and the regulatory issues, and it's so important because the EU and the US represent 30% of world trade and 50% of world GDP. If the EU and the US are not doing this effort together, it will be done by others, and the Chinese are taking up the file, and then the norms will be different and the values will be different, I can tell you here. So it's a very important project also because it has extensive spillover effects, and it will essentially set global standards. And to me, it's just a matter of time until this comes, because the facts of global value chains, of very high division of labor, etc., will force both the US and the EU to move in that direction. And the proposals submitted by the EU are very far-reaching in this respect, and they're proposing in these regulatory affairs early information and hearings, transparency, stakeholder consultation, impact assessment, possibly the extension to federal state level. And then they use the classical tools developed within the European Union here. This is a slide for those who are interested, simply capturing the importance of the topic. I think in all of the TTIP, beyond the rest, like tariffs and services, etc., regulatory cooperation is the most important, and it's the most innovative chapter of the whole venture here. This is simply giving you draft Article 1 of a very extensive chapter, and I do recommend you to look it up on the website of the EU Commission, where all these drafts are actually available for the first time here. The question is, of course, how far can this go? And we have to caution our expectations, because we have, between the US and the EU, very different regulatory traditions here. The United States is essentially working on product liability rules, and the Europeans are working on the precautionary principle and strict liability. This is quite different here. The US is pushing for deregulation, while the EU has a strong approach to delegate standard setting to private organizations. But perhaps the most important difference is that the United States has a central law enforcement system based upon penal law, which is very powerful, and has a legal tradition where the authorities are not afraid to use their penal powers. This is quite different in Europe. If you take the diesel scandal, it's not an accident that the diesel scandal was prosecuted in the United States and not in one of the European countries. So the US is actually quite cautious in engaging in regulatory cooperation, because they are afraid that the standards will not be properly implemented in Europe, and that's something one has to think about here. But going beyond this, I think since we talk about the normative challenges here, I think that the shift in trade policy towards regulatory affairs and trade regulation actually raises a lot of very, very fundamental issues here in terms of public law and public policy. And this slide just gives you a few of these issues. I'd like to take up perhaps the last one. What role of legislators in civil society in addressing these behind-the-border issues? How should they be, and can they be included? And of course, the fundamental question here is, first of all, how much division of labor do we want? Now, the current policy of the United States, going back to their protectionist and isolationist traditions here, seeks to reduce the international division of labor, and we will see what will be the result. It will destroy jobs. It may create new jobs here, but will consumers accept higher prices, lower offers, and less quality to reduce competition? We will see. And will shareholders accept destruction of international value chains? If you read the press the other day, the shares have slumped due to these trade policy measures imposed by the United States government here. But on the other hand, will voters accept increasing transfers power to the executive branch, which goes hand in hand with international coordination and cooperation here? And these are fundamental challenges we need to address. My view and my suggestion here is that in order to do this, we have to rethink the notion of sovereignty. Sovereignty, the way it's used today, essentially is limited to self-determination, independence, and freedom from external control here. And if you go back to the original writers on sovereignty, Baudin or Hobbes, who wrote during the European religious wars, their goal was actually to establish order, peace, and stability and welfare. And I think we need to rediscover this part of the sovereignty debate, and then we may be able to achieve a better perception of cooperative sovereignty, which is required to move forward in regulatory affairs. This is just an excerpt from Jean Baudin's books, which I think which indicates this public welfare function of sovereignty, which has been lost here. The other element I think we need to introduce is the doctrine of multi-level governance here. We have to realize that public affairs are addressed on very different layers of governments. I call this the five-story house here. And the question is, on what level do we produce public goods in the best way. Where should we pitch a particular task? Should it be local? Should it be regional? Should it be national? Should it be continental? Should it be global? You can take any field like climate change where these tasks will have to be allocated. We always have reasonable disagreement on these issues, but that's the essence of the political process, and that's why we need to bring in democratically legitimate, inclusive decision-making processes in regulatory affairs. And that is where trade policy still lags behind, because trade policy, the way it's formulated, is still out of the age of tariff reductions. It is not adapted properly to the field of the regulatory affairs. And this is also the explanation why, for example, in the CETA agreement, one regional parliament, Bologna, was able to block essentially the adoption of the whole agreement because the process is backloaded. Democratically legitimate bodies in the EU today can only address trade policy at the very end of the process when the agreement is on the table, ready for ratification and signature here. And I think what needs to be done is to front-load trade policy and to make sure that democratic inputs can be made at the very outset of the process here. And this is what I would suggest you to study the impact of the 1974 US Trade Act. In the United States, trade policy is essentially a prerogative of Congress, and they delegate powers to the president. They now realize that they probably delegated too much power to the president, and they may take it back at some time. In Europe, it's the other way around. Trade policy is a prerogative of the executive, and parliaments are struggling to actually have sufficient influence in this process of regulatory convergence here. And it's not a matter of, I don't have the time to explain how this American system here works, but it makes sure that in conclusion of trade agreements and in preparing the implementation legislation, the US Congress has sufficient say, and the deal is then with the Trade Promotion Authority that if these inputs are sufficiently respected, that they will not alter the agreements by adopting, deviating domestic legislation here. What is very important is that the US Trade Act sets out the objectives which the administration should achieve in terms of trade policy. It sets out the values which they should achieve here. For example, protecting labor rights here. And then when the government comes back with an agreement, essentially they measure it against these values here. I think the same thing should be aspired in the European Union. I think the European Union should develop a European Trade Act, which essentially contains the essential values which trade policy should achieve beyond the ones I mentioned, also relating to labor standards, to human rights, to environmental goals, etc. And this regulation, which you could in which you could frame it, would of course be subject to the whole legislative process. It would even go into the national parliament subject to protocols 1 and 2, and they could use the yellow or the red cards here. So you would avoid what happened in Bologna. Bologna would be consulted at the very beginning of the process, not at the end of it here. And then once you have such an act, I think you still would then have specific trade negotiating mandates by the Council, but I think overall we would have a better foundation to address these regulatory affairs, and we would have a higher democratic legitimacy than what we have today. And I do think the European Union should use the time now where TTIP is in the drawers because of this current administration. The subject matter will come back. The United States industries, the shareholders, the consumers will not agree to give up the global value chains.
So the government will be forced to go back into regulatory affairs. The first one will be data protection, probably. And in the meantime, the Europeans should prepare the democratic process to address these issues successfully. Thank you.
Thank you very much, Professor Cottier. The European Union has not there is no an EU trade act, but there are other provisions that can be used and that had been used by the Court of Justice many times. For instance, the Charter of Fundamental Rights has been used in order to annul a directive, and also the provisions having general application in TFU, notably Article 11 to 14. They are cross-cutting provision, consumer protection, environment, services having general interest, and so on. So this provision can also use in order to annul an act, also to ask an opinion to the Court of Justice before concluding an act. So I think that values and rights should be already part of the lawmaking of the EU every day, also without an act, a specific EU trade act. I think that we have the instrument, but it is a good idea anyway, because it is, as it was for the Charter, the rights existed, but nobody knew them. So maybe a new trade act could be useful in order to make the EU values known outside the EU, because maybe the partners in trade will read, they don't read the Charter of Fundamental Rights of the EU, but they could read, and in the negotiation they should know what are the specific approach in concluding trade agreements inspired to the EU fundamental values. So thank you very much. And we have now Cécile Rapoport, who is, excuse me, also a member of our network. I was automatically switching to French. And she's professor, also Professor at Rennes, but is also member of the Institut Universitaire de France. She's member of the steering committee of our network, as is Isabelle Bosse-Platière. And she's going to speak to us of constitutional monitoring of mixed free trade agreements by the courts of the member states. You have the floor.
Thank you, Lucia. Hello, everyone. I'm very thankful to my colleagues for organizing this conference. It's always a pleasure to come to University of Bologna, and being one of the 6 coordinators of the LAwTTIP project, I must say that belonging to such a network is with Bologna and King's College is a great and very instructive adventure. So thank you. The presentation I will make is built on a paper. Do you hear me okay? I need to speak closer? Okay. It's built on a paper which should be published soon in the European papers, and which I wrote with Dr. Marie-Cécile Cadillac, who is presently doing an internship at the European Parliament in Brussels. So she couldn't be here today. My presentation focuses on the French Constitutional Council, which in France we call, and which I will call, Conseil Constitutionnel. But a few other constitutional courts are currently monitoring EU mixed agreements. In particular, more precisely, they are monitoring the Comprehensive Economic Trade Agreements, the CETA, between the EU, its member states, and Canada. There has already been 2 preliminary rulings of the German Bundesverfassungsgericht, one of 13th of October 2016, which set out necessary preconditions for the signing of the CETA by the German government. Also one of December 2016, in which the German Federal Court rules that the government didn't fail to respect the precondition established in October, the October ruling. But there's also a case concerning CETA pending before the Federal Court of Canada, since October 2016. Conseil constitutionnel is, however, the first constitutional court to rule a final decision on the substance concerning the compatibility of CETA with the national constitution, the French constitution. In France, the Conseil constitutionnel is the court able to control the conformity of laws and international agreements to the French constitution, whereas Conseil d'État or Cour de cassation review constitutionality of infra-legislative norms and also conformity of laws with international agreements of France, such as EU law, for instance. The specific case I will focus on today is very interesting both from an EU law and a constitutional law perspective, because it raises the question of the tasks of the constitutional judge of a member state of the EU when confronted to a mixed agreement, which, as you all know, are signed and ratified by both the EU and its member states. So my presentation will go over 3 points. First, I will start with some basics on French constitutional law, which you may all not be familiar with. Then I'll speak a little about the CETA case before the Conseil constitutionnel, and I will draw a few lessons from this case regarding the monitoring of mixed agreements by member states' constitutional courts. So, a few basics elements on constitutional review by Conseil constitutionnel. First, there are 3 possible legal bases for monitoring laws or agreements in the French Constitution. You have 3 legal bases. Article 61 of the Constitution is an a priori monitoring of laws, and possibly laws authorizing ratification of treaties, of mixed treaties, for example. Article 61-1 is an a posteriori monitoring of laws. For example, it's the specific procedure, specific collaboration with common courts called priority preliminary ruling on constitutionality. And Article 54, which is the one who interests us today, is an a priori monitoring of international undertakings which needs authorization for ratification. According to this provision, according to this Article 54, if the Constitutional Council, on the referral from the President of the Republic, from the Prime Minister, from the President of one of the other houses, or from 60 members of the National Assembly or 60 senators, has held that an international undertaking contains a clause contrary to the Constitution, authorization to ratify or approve the international undertaking involved may be given only after amending the Constitution. So, 2 comments on this provision. My first comments concern the effect of Article 54. In the end, Article 54 aims at determining whether the ratification of the national agreement by France can intervene without beforehand amending the Constitution. It appears to be very similar to the opinion procedure in the writing of it. The opinion procedure of Article 218, paragraph 11 of TF-EU. But in practice, the results are usually different. At the EU level, a negative opinion leads to a modification of the agreement or the end of the conclusion process. In France, it isn't rare to see the government initiating a constitutional amendment to the Constitution in order to be able to be in a position to ratify the international agreement. My second comment is concerning the use of this procedure. Unlike Article 61 or Article 61-1, which are regularly used, Article 54 is rarely activated. Interestingly, 9 out of 14 activation concern commitments France made in the framework of the European integration process. 5 rulings dealt with the revision of the European treaties, Maastricht, Amsterdam, Lisbon, and the Constitutional Treaty. 3 concerned member states' commitments regarding other EU treaties, such as Treaty on Stability, Coordination and Governance in the Economic and Monetary Union, such as the Treaty of Luxembourg, for instance. And within these all 14 cases, a revision of the Constitution has been requested in 7 cases and has been completed in 6 of them. So you see, quite different from the situation at the EU level. So now, what are the constitutional norms of reference to run the monitoring of the agreement? The Conseil constitutionnel controls the compatibility of international agreements with all legal sources that are part of what we call in France bloc de constitutionnalité, and that have been reckoned a constitutional value. So this includes not only the 1958 Constitution itself, but also the preamble of the 1958 Constitution, which refers to several other texts, which are the preamble of the Constitution of the Fourth Republic of 1946, the 1789 Declaration of Rights of the Man and of the Citizens, and since 2005, the Environment Charter. So now the CETA case. The CETA was referred to Conseil constitutionnel by 110 members of the French Parliament coming from both assemblies, National Assembly and the Senate, in February 2017. The Conseil constitutionnel gave its decision approximately 5 months later, which is unusually late, for it traditionally delivers its ruling within 1 month under this procedure. But as we'll see, it was obviously necessary for the Conseil constitutionnel to wait for the opinion 215 to be delivered before delivering its own rulings. So there was 4 main grievances against CETA coming from the applicants. Applicants, members of the parliaments, claimed that CETA would weaken France's capacity to exercise its normative activity. And they suggest that the CETA would run contrary to what we call the essential conditions of for exercising national sovereignty. They also claim that the breach of the essential conditions for exercising national sovereignty would also occur because of stipulation related to provisional application of the agreement and also conditions of its termination. The applicants also contested the constitutionality of provisions of Section F of Chapter 8 of the CETA agreement, which are concerning investment law. And for this specific claim, they considered that the CETA would infringe specifically Article 88-1 of the Constitution, which is quite interesting because they argued that since ISDS, investor-state dispute settlement, illegally affected the courts of justice jurisdiction, because it allows investor-state litigation to be brought before a specific court, France could not apply this provision without violating EU law. and subsequently violating Article 88-1 of the French Constitution, out of which the Conseil constitutionnel has set out a constitutional obligation to respect EU law. The Conseil constitutionnel rejected this path and confirmed its traditional jurisprudence, according to which it has no jurisdiction to assess the compatibility of an international commitment with France's other international and European commitments. They also considered that ISDS mechanism was an infringement of several constitutional rights and freedoms, such as principle of independence or impartiality, and also principle of equality before law. And finally, applicants claim that the agreement infringed on the principle of precaution laid out in Article 5 of the Environmental Charter, which, like I said before, has a constitutional value. So that was an infringement of a constitutional provision. So what was the answer of Conseil constitutionnel to all those claims? Well, Conseil constitutionnel rejected all the claims. So there's no infringement of equality principle, impartiality principle, and so on. The CETA does not contain unconstitutional clauses for Conseil constitutionnel, so I ran out of time to develop how it rejected each of them, but what I can say is that the applicants might have found the legal reasoning maybe a bit frustrating, because when rejected each of the claims, the ruling mainly quotes the CETA and describes its provision, but refuses to go further. And why is that? It's because going further would mean having a national interpretation of the CETA provisions, so a national interpretation of EU law. So this leads me to the lessons that we can learn from this ruling when it comes to the monitoring of mixed agreements by member states' constitutional courts. Two main lessons, I think. Lesson one is that the specific nature of mixed agreements impacts on the monitoring method of constitutional courts. At least from a national point of view, mixed agreements are a hybrid source of law. As any EU act, it takes precedence over national law, even constitutional one. And in France, the conciliation of the EU primacy principle with the supremacy of the French constitutions lies within the Article 88-1 that I quoted earlier. So this is the provision, famous Article 81-1. What's interesting is the way the Conseil constitutionnel interpreted this article, because it inferred from this provision that a constitutional obligation for French laws to respect, for French laws and for French institutions, for French laws to respect EU law and for French institutions to transpose EU directives, no matter what other constitutional provision they may challenge, as long as rules and principles inherent to the constitutional identity of France are safe. So this is an approach established for EU directives, which now also, we'll see, partially applies to mixed agreements. Of course, we do not know what a principle inherent to constitutional identity of France is really, concretely. So it's an EU act, but a mixed agreement is also an international agreement from a constitutional point of view. So the mixed agreement may also trigger the method used by Conseil constitutionnel, when monitoring national undertakings of the French Republic in the framework of Article 54 of the Constitution. And this method consists in verifying whether the provisions contain a clause that is unconstitutional, calls into question rights and freedoms guaranteed by the Constitution, or runs contrary to the essential conditions for the exercise of national sovereignty. Instead of choosing one method or the other, Conseil Constitutional chose to combine both methods, taking account of the division of competences between the EU and its member states as it is established in Opinion 215, which explains why it delayed its ruling. The nature and presumably the extent of its control varies according to the nature of the EU competence. Concerning the provisions that fall under shared or retained competences, the Conseil Constitutionnel shall apply the method attached to the monitoring of international undertakings. That is, verifying whether the provision contains a clause that is unconstitutional, call into questions the rights of freedom guaranteed by the Constitution, or runs contrary to the essential conditions for the exercise of national sovereignty. As for the provisions that fall under an exclusive competence of the EU, Conseil Constitutionnel shall only check that they do not call into question a rule or principle inherent to the constitutional identity of France. I must add here that this solution means that Conseil Constitutionnel agrees or considers itself competent to monitor provisions falling under exclusive competence. And this was not the proposal or the argument of the French government, which considered that since it was exclusive competence, the Conseil Constitutionnel didn't have any competency to monitor a ruling on those provisions. So at first glance, the room of maneuver of the Conseil Constitutionnel depends on the nature of the competence. However, the CETA case shows that actually, in both cases, exclusive or non-exclusive, the French constitutional judge isn't really in a position to do much more than stick to the literal interpretation of EU mixed agreements. And this leads me to my second lesson that we can learn from this case, with which I shall conclude my presentation. The second lesson is that the constitutional judge actually works with a narrow room of maneuver when it monitors an EU mixed agreements. Regardless the nature of competences at stake, the Conseil Constitutionnel's margin of maneuver appears to be quite narrow. On the one hand, the procedure enshrined in Article 54 of the Constitution, being a preventive procedure, Conseil Constitutionnel cannot rely on the potential effects of the agreements to make up its mind regarding its compatibility with the French Constitution. On the other hand, its task cannot compete with the monopoly of the Court of Justice with regards to interpreting EU law. Therefore, Conseil Constitutionnel cannot do much more than quoting the agreement and interpreting its own constitutional standards. So in the end, monitoring provisions falling under shared or exclusive competence might not be so different when it comes to the effective margin of maneuvers granted to the Conseil Constitutionnel. Actually, such a conclusion shouldn't be that surprising, because when it comes to EU secondary law, including EU mixed agreements, the Conseil Constitutionnel deals with developments of the EU integrative project. So there should be no reason why its control should be more intense with EU mixed agreements than with EU directive adopt in a matter of shared competence or a law transposing EU directive, of course. The situation is, of course, different when Conseil Constitutionnel deals with the revision of EU treaties, because for those, France acts as a fully sovereign state and not as a member state. Thank you for your attention.
Thank you very much, Cécile. I was thinking at our constitutional court, we have not developed so far a specific approach to trade, and probably because it is perceived as a matter that passes through the competence of the European Union. So at the moment, our constitutional court is more focused on criminal matters, the Taricco, but not only Taricco. We will see whether we will develop a similar approach. So thank you very much to all our panelists. If there is any question from our public, I think we have a few minutes. We have a shy public. Okay, one question. Take the micro, please. Abbiamo il gelato.
Yeah, so sorry, I arrived late and I missed the first presentation. I'd just like to ask Professor Rapoport about the interpretation of mixed agreements by the French court. Is there much legal argument and debate about the interpretation, or is it always sort of straightforward? And what kind of legal discourse or argumentation is there about the interpretation of mixed agreements by French lawyers? I just want. Sorry. Okay. Maybe I can speak more clearly. Is it better?
Maybe we can collect all the questions. Yes, we have one more there.
So, what do lawyers argue? Sorry, what do lawyers argue about? So, what do lawyers argue about in the condition?
What the lawyers argue about?
Okay. So the question is, basically, is there a debate on the solution from Conseil Constitutionnel? Not on the substantial issue. I think most of the academics and doctrine consider that CETA is constitutional, if this is the question. And that's interesting because some of the principle towards which it referred to doing the control, like the equality principle or impartiality principle, are general principle of EU law also. So it's interesting, but they are interpreted as constitutional principles. So they do not. I mean, they can give hints to the ECJ, for instance, in its opinion 117, but it doesn't bind it at all because it stays constitutional principles, and ECJ can have its own interpretation of equality principle, for instance. So, but when you read the decision, it's a bit frustrating because it's not very developed how the justification is quite superficial, I must say, and it usually uses quotation of the CETA, so it's a bit frustrating, even for the academics.
I see that Professor Neuvel has a question. Non c'è quello.
Thank you. I would like to thank all the speakers for these wonderful and very substantial contributions. Now, I don't want to ask all of you a question, but if I want to make a choice, can I ask Professor Cottier a question? If I understood you correctly, you said it would be good to upfront the trade debates and to give regional parliaments a say. You actually formulated it saying to consult the regional parliaments at the very beginning of the process. Now, if I'm not mistaken, that this has actually been the case in the context of CETA, because there are discussions with Parliament. And I think one of the objections of Paul Monnet was not that he was not consulted or that his parliament was not consulted, but that he wanted to have a meaningful say in the debate. And the only way is to actually have a direct incidence on the formulation of the agreement, which then resulted in the interpretative declaration. Thank you.
Thank you very much. Now, if we look at the ordinary process to establish the mandate, the negotiating mandate, this for many years was done between the Council and the Commission, and later on the European Parliament was consulted in adopting these negotiating mandates. When you look at the mandates, they're actually quite rudimentary. Key issues are not really addressed because you don't want to raise very difficult issues. So, for example, the question whether portfolio investment should be included or not is not debated out in the mandate here. Or other issues like how to approach questions relating to GMOs is not being addressed. So these mandates are not detailed here, and I think if one would adopt the approach of sorting out these fundamental issues and generate the public debate in Europe on trade policy, using to this effect a draft regulation which would be circulated and which would need to be adopted upon consultation by also the national parliaments here, I think the legitimacy of trade policy would increase. That I think is the step. The question is, in the end, whether it is appropriate to give blocking powers to a regional parliament. I think that's up to the European Union to decide if they want to basically render their treaty-making power redundant. That would be the way to go. Fortunately, you dealt with Canada in CETA. Canada has a very complex domestic configuration with the provinces, so they know why this happened and they were able to deal with it. But other countries may be much more frustrated if, in the end of the day, one parliament could block the deal. So I think by front-loading these decisions, it may take a bit longer in time, but you can sort things out and you can make sure that all the voices have a say. You also would make sure that the right issues are being discussed. You know, for example, in TTIP, there was so much debate on chloride chicken. Chloride chicken is simply not an issue. But other issues were not discussed. For example, increasing patent protection and the implication this has on the health sector was not discussed. So these things, I hope, would come out if one would address objectives and values negotiators should achieve. And I do say that the experience in the United States in going back and forth with Congress and defining objects, reporting back, etc., has overall worked out quite well. Of course, you may not agree with US trade policy as such, but they don't really have had the same deficits in terms of input by Congress and the parties and politicians. Yeah. Perhaps it's useful to allude to the hormones dispute in that respect, in which I was involved. There was a value judgment in the European Union going back to domestic scandals of abuse with hormone treatment, that you want to ban the use of hormone for the elevation of cattle, but not for pigs at the time. And then as a flanking measure, you would also ban imported beef, which was treated that way, and that affected US and Canadians. Now, from a WTO perspective, that measure was considered to be unlawful because the EU was not able to show that there is a risk to health by using in an inappropriate veterinary process these hormones. But in the end of the day, nobody could force the European Union to change their laws, and they essentially paid a price by paying compensation in other fields. But the standard is still there, so you can't actually force the European Union to change these laws. And you also cannot force the European Union to change these laws in bilateral agreements when you negotiate with the US. In terms of market shares, size and power, they're par. The US is not in a position to impose these standards. So if in the European Union you just don't want to have chloride chicken, you won't have them. That's it. And you don't agree to that. And there's no mechanism that the EU would be forced to accept chloride chicken on their markets, as much as they're not forced to accept Chinese chicken, etc., for phytosanitary purposes on their market if they don't want to do it. The SPS agreement, etc., allows you to take the appropriate measures, even if. And de facto, even if it's a moral standard, if it's a scientifically proven standard, then even lawfully, it's no problem at all. So I think it's a matter of standing the ground, and Mrs. Malmström had said it very clearly that there's not in TTIP, it's not a matter of lowering European food standards, full stop here. And I think the EU has the leverage to do so. Back in the time of biotechnology, the effect was that in the United States, the farmers started to adjust their production in order to accommodate European markets. It was not the other way around, that the EU would import more biotech products. So in terms of the markets, the EU has the possibility to live up to these values if they want to. And I think that would be the same in TTIP. But my point is other issues are much more dangerous, like enhanced patent protection, etc., on where this will boil down in very strong increases in health costs, and these things are not being discussed, and we should have a mechanism that these things do come on the table.
If there is no other question, yes, one, please.
Gosh, it takes guts to come here. Fortunately, I have them. It's a bit like being the accused in a court of law. Question to Professor Cardwell. Putting myself into the shoes of a third country negotiating with the EU, and perhaps not a country like the US that has got a similar system. What's wrong with good old-fashioned self-interest? So I guess my question would be, why can't we talk about free trade and you stop lecturing me about all these other issues like the rule of law and democracy?
You don't mean me? Okay, that's fine. Okay, so, I mean, certainly on the part of third countries, and we know for a long time when, you know, the EU has said, well, we're going to put, you know, values and we're going to discuss things and not going to be afraid, and we know that has sometimes been an obstacle. I mean, to take an example of when I was in Japan, at that time, I mean, a free trade agreement with Japan was still very, very far away, but nevertheless, in this dialogue that had been established between the EU, the Commission delegation as it was at the time, and the Japanese government, you know, the EU put onto the table issues about free trade, but also, you know, non-economic issues as well, such as, again, to come back to the example of the death penalty, which Japan uses fairly regularly and in circumstances which raise questions such as the accused or the person that's going to be executed doesn't know until they actually get collected from their cells. So it could just be surprise any day, which is coming for criticism. And I was there when this is raised, and you know, the Japanese just say, well, what are you talking about that? A, it's nothing to do with you. B, it has public support here, therefore it's not a matter for discussion. And, you know, we're a democracy. Why are you, you know, keep that kind of dialogue perhaps for countries elsewhere in the world? And so I think probably since then, a lot of countries have become used to the EU, well, you know, actually, you know, does this more regularly, whether it's not these kind of values or other ones, you know, in trade as well. But it makes you think then of what other things that will come up and where they come from. So the chlorinated chicken is a good example that's also come back up again, as you'll know in the UK about post-Brexit deals with America, the chlorinated chicken thing has come back. And you think, well, this is going to be put on the table, not literally on the dinner table, but maybe, because of sort of public pressure, the idea is being talked about rather than some of the, perhaps, I agree, more important things. So I think on the part of third countries, I think because the European Union has become more known in terms of what it does, but there is definitely a sense of, you know, why are you lecturing? What would be interesting now, and what I know less about, would be now that the EU is enlarged, of course, we see more, you know, variety, let's say, in opinions expressed by member states about democracy and the way it should be interpreted and so on, and whether that has an impact on third states as well. And I suspect it might do, particularly in the neighbourhood, which, again, to go back to what I said, is the focus within the treaty of where the promotion of values on the part of the EU should be.
Could I make a comment on this? I was wondering, following your lecture, whether there is a distinction between, which is made in constitutional law, the Constitution as an instrument of government, or are the Constitution expressing fundamental values? And I think the EU has followed the Germanic approach after World War II with human dignity and all the values enshrined in the Constitution, while the US doesn't express these values as such, and the UK also not. And the question would be, which way should one go? With the current system, there is a risk that the values are frustrated. I'm just thinking about all the talk about human dignity and human rights, and then what the EU does in migration and letting down Italy on the refugees here. So, I mean, this is a clear case of self-interest, the way it was run. So what is your view? How should this be handled? You know, is it a wide thing to create all these expectations? And by the way, on the chloride chicken, I want to say, in the power relations, the Brits will have to accept chloride chickens because they don't have the power to stand against US pressures if they want to sell access to financial services at the same time. That's the Brexit situation.
Yeah, I'm just happy I'm vegetarian. I agree, yeah. And I think most people in their right mind would realise that too, unfortunately. No, I'll leave it there. I mean, the response to the values one is, to be honest, I don't know. Because if you see, and certainly in the migration context, even beyond the constitutional values, but the way in which the protections are supposed to be there, to be able to be challenged, things we see with the EU-Turkey deal, sometimes called an agreement, and it's not. An agreement is something which is, there's a process of making it according to the treaty, and it can be challenged, and the deal with Turkey is not. And so when there was a challenge in the General Court, the court said, oh, well, this is inadmissible because there's no such agreement. It's not made in the name of the EU. It's made with the member states acting collectively, even though the EU issued it. And this is a way almost to get around the protections, the constitutional protections, if you like, that are afforded, because then actually it solves this tricky. So we deny this is a problem by pretending it's not there. And that seems to me then almost a victim of, well, we place these values, central, say we're a values, led actor and a normative actor and so on, but actually in order to get things done, we have to put those aside. So either you get rid of the values from the treaty and stop admitting and just say, well, actually, there's the EU acts as a self-interested actor. But then again, we see the problem of, well, where does the EU's legitimacy and where does its continuation? And again, this is something else that's come about through, or that's sort of come to light a little bit in Brexit, where people who are pro-European are then sort of reflecting on, well, actually you have to defend everything the EU does, even if it's things that you don't necessarily like, whether it's TTIP or whether it's aspects of migration and so on. So it's been one of the things that people have had to reflect on beyond chlorinated chicken and blue passports, French-made blue passports.
Okay, so many thanks again to our panelists. We have now 15 minutes of a break. There is no coffee, I'm sorry. Just a no coffee break.
There's no coffee.
No, there is no coffee.
think that we may resume our works. Therefore, I invite the speaker to the table. And since without them it's quindi perfetto. Sì, Cottier ci ha dato il premio a Parigi, dunque e vi ha detto anche che vogliamo fare una cosa tutta in francese. Per il secondo sì. Chiedi il filone che ci abbiamo a Michele. Ottimo. Pietro Manzini, salve, noi ci conosciamo dalla distanza più formalmente adesso. A distanza, ogni tanto anche bene vedersi in persona. Chi è il primo qua? Chi è il primo? Ok. PowerPoint? Sì. Ok. Ok, perfetto. Sì. L'unica cosa che manca sono gli occhiali. That's it. Thank you very much. We resume our works now. Second session devoted to the sectoral challenges to the effective protection of EU fundamental rights and values. We have three distinguished speakers. The first one is Laurent Manderieu, which is one of the foremost experts on intellectual property law, and I think everybody knows him. He also teaches at the University of Bocconi in Milan, and his intervention is on intellectual property rights. Well, that's convenient since he's one of the most important experts. So I give you the floor. Thank you. Sure.
I understand the acoustics in the back of the room is not excellent, though the room is marvelous. So it's a pleasure, it's an honor to be with you today, to be with all of you. I really would like to thank Professor Rossi, Professor Casolari, and all the consortium for having invited me to this great event dedicated to TTIP. And now, after we've reviewed together more general considerations, we are entering into the detailed study of sectoral aspects of the half-dead TTIP, which, by the way, could in a way or another wake up. My duty is to present the issue of intellectual property rights, an issue which in the transatlantic context doesn't seem to be the most complicated one. Actually, both regions, the EU as a region and the US as a country, promote strong standards on intellectual property. The objective of this brief presentation will be to review how the draft TTIP compares with current FTAs of the EU, why the work that has been done for TTIP helps us in foreseeing not only a transatlantic future but also other negotiations that are taking place between partners of the OECD, and also to try to analyze whether there is really a transatlantic consensus on this very topic. So, first of all, let's very rapidly review the EU standard agenda in negotiating free trade agreements. The European agenda is an agenda for strong protection of all intellectual property rights, similar, as already mentioned, to the one of the United States of America. It is also an agenda for strong enforcement of rights by third countries mostly, and this is also the agenda of the US. Similar to the US, the EU promotes the inclusion, the systematic inclusion of an intellectual property chapter in the FTAs that are actually negotiated and in all the most recent FTAs of the EU. Even if my predecessors in the previous session mentioned that the topic, the format of FTA is perhaps an outdated format, being still the current format, this is how the EU, like the US, work. The EU also has a specific agenda, which is its main clashing agenda with the US, the protection of geographical indications, an agenda which within the EU has been much pushed forward by some member states, Italy, France, Spain, other European countries, an agenda that will, with the Brexit, possibly be further strengthened. So, what are the most important EU FTAs for intellectual property? There are more than 20 agreements, plus a dozen of draft agreements currently. Since the EU CARICOM, now CARIFORUM agreement, there are intellectual property provisions that include rights protection and enforcement principles. Still, for what interests us today, the transatlantic area, there are EU FTAs with Asian countries that draw our particular attention. The EU FTA with the Republic of Korea, with South Korea, and the EU FTA with Singapore. Since these countries are OECD countries, and therefore, as the US, these are agreements that can be considered as model agreements, though the negotiations for the TTIP seem to diverge from these agreements, as we will see rapidly later on. The EU-specific agenda in negotiating with the US is relative to various categories of rights, and the EU and the US are in theory cosmetically in agreement. They are the two areas of the world, strongly, jointly with other countries that are not in the EU or in the US bloc, such as, for example, Switzerland. They are in favor of strong IP right protection, strong standards. Both EU and US have an IPR agenda which is largely business-driven. Many of you, many scholars present today remember the debates on ACTA, on the failed ACTA, and in the debate on the failed ACTA, it was very clear that part of civil society opposed these chapters on intellectual property very strongly. However, the depth and the development of IPR protection in both areas is different for two reasons. First of all, political organization for creating more rights, and also for technical reasons. For technical reasons, the way the IP rights have been conceived internally within the two blocks, the history of the legal systems is different, and therefore the IP rules are not consolidated in the same way. While negotiating an agreement between the two blocks, this history of laws, the current laws as a result of history, show discrepancies that render difficult their further harmonization, though not impossible between partners sharing the same objectives. The EU-specific agenda in negotiating with the US is marked by, of course, the political differences for creating more rights. The EU is the sole actor for negotiating TTIP, whereas the US is the sole actor as well. But the US has, well, whereas the US, as my colleagues Thomas Cottier and Cécile Rapoport presented, the US and the EU have differences in this aspect. The US and the EU still, in the techniques of making agreements, still the US and the EU have differences in the way the competence exists for the state to negotiate. The EU has a shared competence between EU institutions on IP. It has also some areas which are not within the mandate of the EU, such as the mandate of the European Patent Organization that comprises other heavyweight non-EU member states, Switzerland, Norway, and because of its size, Turkey. Therefore, the EU has a weak mandate in negotiating FTAs in the field of intellectual property. And this reflects the weak mandate the EU has internally from the Lisbon treaties, from the two treaties, in negotiating, in making IP law. The US is a single actor, though the federal states shares, but with a very limited extent, some competences with the US states. But the US has an integrated IP policy. The EU has a partly integrated IP policy, integrated for trademarks, for industrial designs, harmonized for copyrights, and not harmonized or partly harmonized for patent granting. The specific EU agenda in negotiating with the US shows differences, technical differences in various fields, mostly patents, enforcement, grace period, to a certain extent copyright, but this sounds to be sorted out rapidly, geographical indications, pharmaceuticals, genetic resources, and traditional knowledge. On patents, it is a knowledge worldwide that the EPO system, the quality of the EPO patents, make European patents of the best of the world in terms of quality, in terms of granting procedures, and the USPTO, the United States Patent and Trademark Office of the US commissioners, US secretaries of state, acknowledge this fact. The US is therefore interested indirectly, though not officially, in lowering the standard to make it closer to its own standard. And in addition to this, US standardization organizations currently seem to favor lesser value for patents, at least lesser than European bodies. So, though altogether the EU again and the US share the same objectives, on thematic issues such as patents, the EU has a more rigid approach for better quality. On enforcement, the EU system for industrial property rights, not for copyrights, leaves large part for pre-grant challenging. This system does not exist in the US, and this brings, of course, any patent issue to litigation. And the litigation system in the US, as we all pretty well know, is extremely expensive, is very costly, and therefore it excludes US and European SMEs, mostly US SMEs, but also European SMEs, for being in a position to defend their rights. And by the way, also European universities, which can't litigate at the US costs. So the EU would wish to see developing in the US, and that's a very long-standing effort, different enforcement mechanisms. The US admits a grace period, which the EU refuses, despite the effort of the universities to get grace periods admitted, of European universities. And this is, of course, a big difference. The US wants the EU to introduce a grace period, such as Japan and China are inclined to do or did. And as such, this is a big transatlantic controversial issue. On copyright and related rights, the EU would wish to have a larger protection, mostly for moral rights, and also for the rights of broadcasters and for audiovisual rights. This controversy is likely to be sorted out more rapidly than other chapters, so I wouldn't insist on this. On geographical indications, the EU has spent, not only with the US, but worldwide, an immense amount of its negotiation credit and diplomatic efforts in obtaining standards that respect European geographical indications, or with third countries that impose or push these countries to adopt protection of geographical indications, even in their own national order for their own national products. This opposes considerably the US and the EU. The subject, which represents one of the largest efforts of the EU, as already mentioned, is taboo for the EU, if I may say. Whether the EU spends an immense amount of its efforts forgetting other topics or whether it is right to be a taboo could be the purpose of a completely different and other conference. Pharmaceuticals. On pharmaceuticals, the EU and the US, jointly with Switzerland, Japan, and some smaller actors such as Israel, are the key players of the industry, and they don't exactly have the same techniques. In particular, the EU, pushed by this time by non-business actors, wants to leave larger space for generics, in particular for its generics in the US. Also, some issues that may be treated by other speakers relate to the protection of data, to MTAs, NDAs, and I would leave this issue to other sectoral speakers. On genetic resources and traditional knowledge, there is an opening from the EU to make some element of recognition of, in particular, of genetic resources in patents and of traditional knowledge in other topics, whereas the US has constantly opposed a no to its trading partners on these very topics. So topic by topic, we see that there are differences. These differences still should can be erased the day politics make that the TTIP or what would remain active and valid of the TTIP wakes up, and probably the IP chapter would wake up in a way or another. These divergences may be sorted out in a way or another. The broad structure of the IP chapter for from the EU point of view in the TTIP is the following: common objectives, and the objectives are common: business-driven IP for representing better wealth and growth in our area. The EU alleges, or in its studies, that 40% of the EU industry is IP-driven, and therefore this is a key element of its industry. And the US, parallel to this, presents identical or very similar figures. The second chapter would be compliance with international treaties, making that the EU and the US are members of the same treaties and of all the chapters of the same treaties from the EU point of view. This has its importance in copyright. There would be a narrative, preamble narrative. High standards agreed principle. The EU insists on a specific chapter on geographical indication, a specific one on copyright and related rights, a specific one on cooperation with third countries on IP. There, the objectives of the EU is to avoid that the FTAs negotiated by the EU, by the US, but also possibly by Japan and other OECD partners, create short circuits with third countries. And this is a very interesting and positive initiative. On trade secrets, the new directive of the EU makes possible to negotiate with the US better protection as well. And this is basically the broad IP chapter in the TTIP. Whether we will see it very soon embedded in a revived TTIP, or whether we will see it developing in other transatlantic negotiations remains a question mark for all of us. But in a way or another, part of the work conducted by the EU, by the US, which did not, also for the reasons presented by other speakers on who negotiates and how between Congress and the executive, the US did not expose as much as the EU did on its objectives. One thing is certain, the work that has been done will have a kind of legacy. Though there is a fragile transatlantic alliance on IPRs, we must admit that in negotiation with third parties, the US and the EU have common approaches, they have differences between themselves currently, but in any case, the work conducted until 2016 will have an impact, if not already having an impact, in the FTAs that currently the EU is negotiating. So, TTIP perhaps lost, but the work done for IP on TTIP or in TTIP is not totally lost, at least from the EU's point of view, from what is understood of the EU's approach. Well, thank you for your attention. I think the debate will be at the end of the session, so I'll be at this stage ready to reply to questions. Thank you.
Thank you very much, Professor Manderieu. I think your speak was really interesting. We started with the statement. EU and US are the main actors and both want to protect IP, but when we go into the details, we discover that the approach may be rather different. I now give the floor to Professor Andrea Biondi, which is an old friend of our university. He is well-known, very well-known. He's professor of European law at the King's College, a university with which the University of Bologna has close links. The content of his intervention, it's on state aid control and subsidy regulation in EU FTAs, and this is quite interesting will be quite interesting to hear a bit of Brexit. Is as a stage in which he can really illuminate on the topic. Thank you.
Thank you very much. Thanks, Chair. And obviously, as I did not have the opportunity before, again, on behalf of King's College London, once again, we are extremely pleased and happy to be part of this research project together with our colleagues from Università di Rennes and Università di Bologna. If I may add a very quick personal note, also it's a great pleasure to be in Bologna. As you mentioned, we've been friends for a long time, and apparently we are now celebrating our 10th anniversary of marriage between the two law schools. It's been a very happy marriage, I think, mostly due to the, how can I put it, willpower of Professor Rossi. And we will actually miss you, but I'm sure that you will still look after us from Luxembourg. Anyway, great pleasure. But then let's get to the topic for today. I think I better start perhaps with a disclaimer. The events that unfolded in my country, one of my two countries, starting from June 2016, meant that some, classic EU lawyers, I'm even tempted to say EC lawyers like myself, had to embrace the new brave world of international trade and external relations. So again, I cannot claim to be an expert in the area, and obviously all the speakers that spoke before me and the one that are coming after, they probably know a little bit more about the topic, but let's say life is changing, and call it survival instinct, but it's important to explore new areas. So I have a go. And certainly the topic of today is being one of the most contentious in the aftermath of the referendum. We had a really huge discussion on what kind of model, if any, of public subsidy should actually be applied in the UK. So just to give you a little bit of an idea of what we're going to discuss, it's a long list, but the idea is just to try to explain a little bit why subsidies control and state aid control could be a controversial problem. A little bit of a quick back to basic of the EU system of state aid control, an overview of regulation subsidies in international trade with particular reference to the new generations of free trade agreement, and perhaps, as we are between friends, I will have a go at how the newest international agreement will look like, the one between the EU and the UK, right? Obviously, off the record. Right, okay. First of all, state aid control as an enemy of the people. Now, and I just put two slides here, two quotes, one from a member of the UK government, the Minister for Business, and the other from the leader of the opposition, Mr. Corbyn, which, again, they have something in common, that they see state aid control as a fastidious obstacle in the pursuing of different kinds of policies. From the government perspective, state aid control on public spending is perceived to be as a sort of an obstacle for further liberalization, a bureaucratic constraint on deregulation, you could say on tax gifts, whatever, but on any kind of these kind of policies. And from the other side of the spectrum, state aid control is instead considered as an obstacle to the pursuit of socially responsible policies. In other words, helping the steel industry in Wales, renationalization, and so on and so forth. Obviously, these two quotes are a little bit extreme. They are part of political football. But in my view, there is a little bit of truth in that. Why? Because in reality, every time you discuss, especially in European law and international trade, subsidies control, we are facing with a little bit of what I call a conundrum. On the one side, I think that with very few exceptions, everybody tends to agree that subsidies, aid measures are somehow desirable or sometimes even necessary in order to promote certain kind of public policy objectives, certain kind of common good. In other words, where the market does not dare or doesn't want to get into, is the state that needs to step in. But obviously, at the same time, as we know, they can actually distort trade and also have an impact on the preservation of fair competition. So the question is really how to strike a fair balance. Now, let's start with a little bit the system of EU state aid control. And I apologize in advance because perhaps due to the recent events, I'm becoming a little bit defensive towards the European Union. But I think that if you look at the way the EU has regulated state aid control, it's nearly a perfect balance. Why? Because on the first scale of the balance, I think that state aid control has changed so much over the years. Obviously, it started as an instrument to ensure equality between member states, to tell some of the most generous governments or parties that they could not splash money on their friends, and so on and so forth. And gradually, it became an instrument to ensure equality in the marketplace. And here I just put a quick quote from a Grand Chamber decision, Commission against Spain, where the court speaks about state aid as an expression of EU as an essential task of ensuring that competition in the internal market is not distorted. Again, the economic efficiency is the focus. And again, just to give you a super quick example, if you think about that, I call it the elevation of the market operator principle as a benchmark of EU compliance. That is to say, there's now within the notion of aid, it's an essential requirement to carry out this sort of economic analysis, whereby if the state behaves as a market operator, no state aid. However, if that's not the case, it is actually state aid. And again, here from the Commission notice on aid, if I can just quote on the second part, obviously if the member state does not comply with the market operator principle, the beneficiary undertaking has received an economic advantage which would not have obtained under normal market conditions, placing it in a more favorable position compared to that of its competitors. So a strong focus on economic efficiency. On the other side of the scale, in other words, how to take care of externalities. Again, it's a very sophisticated system. Just to go back to basic, as you know, the treaty, after the straight prohibition contained in Article 107, paragraph 1, does actually include a long list of derogation justification that can be taken into account in order to make an aid compatible. And the pillars of the systems are three. First of all, you have a referee, which is a supranational referee, the European Commission. Secondly, the Commission is entitled to take into account, in deciding whether an aid is compatible or not, a series of externalities from what we call the common good, the common interest, which is really about taking into account labor standards, environmental protection, innovation, whatever you name it. And finally, there's an assessment of the proportionality of the measure. Was the aid really well designed? Was it the only measure that could have been adopted in order to achieve those objectives? And once again, in state aid law, we've been through what I would say is a true legal revolution, because obviously with the adoption of the general block exemption regulation, we moved from an ex ante control to an ex post control, whereby certain kind of public expenditure, research, sport, environmental law, are predefined as good aid. So what I would simply conclude that principles and values like redistribution, cohesion, development, I would add solidarity, are part of the balancing exercise. And again, if I have just pushed the argument a little bit further, and I know this is also slightly controversial, even if you look at the recent case law of the court on the notion of aid, which is supposed to be an objective notion, I think that you can see a little bit of extra flexibility. And I'm just giving you a couple of examples. For instance, the court, in discussing the application of the market operator principle, it says, in a social market economy, a reasonable private investor will not disregard the development of the social, economic, and environmental context in which it continues to develop. So taking into account certain externalities, even within the definition of aid. And again, probably in Italy, you might be familiar with the Point Grafos decision, where the court whispered some very sweet words on the question of fiscal aid to co-ops. To move now to the international side, and this is really quick, obviously you can divide it, I don't know how many fans of subsidies are in the audience, but you can divide it in three broad categories. What I could call the parallel aid systems, that is to say the EA, which is basically the same as EU law. And I know there are a lot of differences, but I would also include also all the agreements with candidates or potential candidates, which are systems which are somehow there as to prepare eventual accession. Then you have obviously the WTO agreement side, which is in particular the subsidies and countervailing measures, the SEM agreement, which deals with subsidies, and finally the new generation free trade agreements, and I think that the most interesting ones are the Korea, CETA up to a point, and Singapore and Vietnam. And I think that here you have a reference actually to a paper that two colleagues of Laurence published, Borlini and Dordi, in the Columbia Journal of European Law 2017, which gives you a very exhaustive list of those agreements dealing with subsidies. Now, again, it's a little bit of a partial snapshot, but if you look at international trade regulation subsidies, I think that on the one side, and probably, I don't know, maybe Professor Cottier would disagree, if you look at the WTO model and the SCMS agreement, I think there's very little, first of all, generally speaking, is of a limited application, and then there is no real solution to this idea of how to integrate certain kind of externalities and public policies. For instance, there is no reference to the chapeau provision under the WTO on Article 20, and probably only through the acrobatics of certain appellate bodies we can actually see a little bit of integration of these kind of values within the subsidies control. However, once we look a little bit outside and we look at the, in particular, I would say, of Korea, Singapore and Vietnam, I think that there are some interesting and intriguing points. First of all, obviously, all the subsidies, the regulations of subsidies are included in the same chapter of competition. They're all under the same umbrella. Secondly, the notion of subsidies is much wider. It does actually include unlimited state guarantees and rescue aid, which are defined per se as unlawful subsidies. They also extend to services, which was a major difference, although not to every kind of service, but to very specific ones. And then finally, generally speaking, there's a sort of general principle that there would be a subsidy when they negatively affect or are likely to affect competition and trade. On the other side of the scale, that is to say, how to take into account some externalities, I think there are also interesting points. First of all, it's said in all these agreements, it says very clearly that subsidies control will not impair the ability of the contracting parties to pursue public policies and fulfill welfare-related duties. There's a very long definition in the Vietnam agreement. Intriguingly, the treaty is basically adopted. Article 107.2 and 3 on compatibility of aid is nearly reproduced word by word, especially in the Vietnam and in the Singapore agreement. Also, there are other interesting points, like for instance, there's no control on subsidies if they are granted as compensation for public service obligation. And then again, there is a replica of Article 106 in the Vietnam agreement. And finally, also, that's a very classic point as well, if there is a serious disturbance in one of the contracting parties' economy, there won't be any control on subsidies. So some comments. So obviously, first of all, we're dealing with free trade agreements, which seems to embrace a little bit more, in the words of Professor Cottier, a little bit of trade regulation model. That is to say, economic efficiency through the fair competition is sort of the aim. And for instance, there is the usual emphasis on anti-dumping regulation. And also I think it's very intriguing that both agreements, they actually provide that if one of the contracting parties thinks that that measure could actually be an unlawful subsidy, this should be remedied by changing the domestic competition law, a sort of ex-ante control. I'll skip that. There will be obviously a lot of problems about interpreting certain kind of basic concept. But I think a general point to be made is that all these agreements, the blueprint is EU language. There's lots of examples. I'll just give you one. Usually public service obligations are sort of the negative list. You simply say education is excluded. Instead, for instance, in these agreements, we're talking about services, compensation for public service obligations. Now, compensation is a word that in European law has a lot of meanings because it's basically the Altmark test. And Altmark means very specific criteria, that you had to have transparent accounts in advance, that you had to have a public tender. So, if words have a meaning, these are European law terminology. Obviously, but again, a big question would be how you're actually going to decide whether a subsidy is compatible. What would be the common good or the common policies that has to be pursued in the context of international agreement? And once again, probably we might end up with the usual ex post adjudication. That is to say, probably the definition of certain key provision will probably be left to the future dispute settlement provisions and settlement authority that is actually provided by these agreements. And in this regard, obviously, a very important point would be to ensure transparency. There's a lot of emphasis in those agreements about transparency, but just to remind you, it's also true that transparency provision is not subject to the dispute settlement procedure under those agreements. And again, obviously, transparency is a strong European law value. So, if I have 5 minutes on Brexit, okay, so this is a little bit the situation. So certain positive things coming up from all these new agreements on subsidy regulations. But then the idea is that even before maybe TTIP, we might have a EU-UK sort of trade agreements. And on state aid and subsidies, I think that it's very clear that from the EU side, there's a huge emphasis on the idea that state aid control is essential. Again, here you have the Council guidelines of April 2017, which makes really the clear link between state aid control and ensuring a level field. And in terms of competition law, you have the Commission slides. Now we learn that during negotiation, you also have to look at the slides, which is a new source of law. Which is probably for, again, old people like me. So anyway, and again, the Commission slides of the 31st of January 2018 says no lowering of standards, in particular, sorry, there's a mistake here, on the following areas: state aid, taxation, environmental and labor standards. And if you look at the evaluation that the Commission itself gives on the free trade agreements that I just discussed, that's the evaluation. They do not address potential disruptive effect of subsidies on investment, trade, and competition. Thus, the Commission continues, the EU-UK agreement will have to include robust provisions on state aid as to ensure a level playing field within the member states. So, we still need a new model. So, if you really need to have a, let's just try to imagine what would be a robust agreement. I guess that you probably need to have an agreement on what kind of substantive law should be included. As far as subsidies and state aid are concerned, probably you need to come up with some kind of ex-ante control to see what we're doing. Still, you might need to provide a sort of a joint committee to decide a little bit about possible divergences in applying these rules. And if things goes bad, you probably need to have a forum for a dispute settlement. And if things are really going bad, you need to come up with some kind of remedies. So what could we have? Seems to me that the only substantive rules that we're talking about are the EU law rules, because whatever you say, they're the blueprint for international trade regulations. So let's have EU law. Obviously, the only form, in order to ensure an ex-ante control, you need to have a new independent authority, and there's already work going on that obviously this kind of power will be given to the Competition and Market Authority, which is the UK Antitrust Authority, which I think would be a good idea, because probably I'm safe ground to say that there won't be any kind of fears of political or regulatory capture. It has a really good reputation. And I think that it would be important for to ensure some kind of domestic, in order, for instance, to ensure solidarity between Scotland and then Wales or UK and stuff like that. And obviously, when you're talking about the UK, you're talking about an economy which is very heavy on the supply side and made a lot of horizontal policies. So in other words, might be a little bit less complicated. So fine, let's have this independent state authority. You might need to set up a joint committee between the EU and the UK in order to check the management of this agreement and supervise possible future divergences. If divergences are going to come up, you need a dispute settlement. And how this dispute settlement will look like? Should we have a joint UK European Court of Justice body? As we know, our friends in Luxembourg, they're not too keen on this idea. Should we have an ad hoc tribunal? As we know, our friends in Luxembourg are not too keen on this idea. Should we have the Ukrainian or Armenian model, which says that basically when you have a problem about subsidies or state aid control, you might have a setup in a ad hoc tribunal with the reference directly to the ECJ, which would make the ECJ responsible for supervising the agreements on subsidies. Very good. And what kind of remedies? Should we still have unilateral remedies? Should we be bold and daring and also adopt the EU remedies, and that is to say recovery of aid? Lots of questions. But obviously, if you simply go through my list, what I'm actually doing is to simply say that this is EU state aid control. So let me finish with a quote from the fourth quartet of T.S. Eliot. What we call the beginning is often the end, and to make an end is to make a beginning. The end is where we start from. Thank you.
Thank you very much, Professor Biondi, for this brilliant speech. That's, in a way, confirms that the Brexit thing, it's really amusing. It's every day I read for 10 minutes British newspaper to start the day with a smile. And I now give the floor to my colleague Giacomo Di Federico, who will speak one of his favorite topic, health care services. Speaking about values, European values. So, please, Giacomo.
Thank you very much. I've been dealing with this topic for some time. I've actually never tackled directly the external side, the external dimension. But I can tell you that this presentation is based on an axiological premise. Although healthcare has certainly a multifaceted nature, with great potential for trade, it is believed that the regulation of health services, I believe at least, and most notably access to primary and secondary health care, is first and foremost a matter of values more than regulation. And this, of course, impacts on the available legal options in the framework of FTAs to uphold what the EU and the member states consider to be their, let's call them red lines from a moral standpoint. Now, that being said, my brief remarks today aim at firstly singling out some of the major perceived, I would say, criticalities of the FTAs, with a particular focus on CETA, though I must warn you. Test these criticalities against the existing agreement, and therefore try to draw some conclusions on the pros and cons of a duly governed liberalization of health services. Now, as my colleague Federico Casolari was mentioning before, Professor Weiler, in a seminar he held in this very room a month ago, pointed out that there is a growing and continuous tension between trade and values as an expression of a given identity. I've translated that from Italian into English because he actually gave a speech in Italian. Now, commercial agreements, therefore, are in some way always conditioned by a sense of spirituality. Now, however bizarre it may appear, this statement, I believe, finds in CETA, and most notably in the provisions on access to healthcare services and on public services, a telling exemplification. Now, before I start, though, a final caveat is needed. Now, in trade agreements such as CETA and TTIP, the main obligations affecting the provision of health and social services can be found in specific chapters dealing with very different topics. Just to mention a few: investment protection, Of course, cross-border trading services, public procurement, temporary entry of service supervisor, and recognition of qualifications. These are, of course, all relevant elements. But my considerations here today will mainly relate to the cross-border trading services, which I think can be, to some extent, isolated from the others, and the impact these agreements are likely to have on the current legal framework concerning the division of competences between the Union and the Member States. Though, having regard to GATS, I shall mainly refer to the cross-border provision of services, which would be Mode 1, where the producer and consumers do not meet in person, it's the service. And consumption abroad, which would match Mode 2, where the customer moves to the producer's location in order to consume the service. Typical examples here are tourism and also patient tourism. Therefore, I will not dwell on other critical issues such as commercial presence, Mode 3, and temporary movement of professionals, Mode 4. Nor will I tackle the controversial issue of investor-state arbitration system, especially in light of the recent ACMEA decision handed down by the Court of Justice. It's already been recalled by Professor Biondi, although implicitly. Now, as is well known, a number of NGOs and consumer and patient organizations have harshly opposed the negotiation process in TTIP and CETA as well, in name of, let's say, our understanding of public services and the right to health care. Now, what I will try to demonstrate that our understanding has changed over the years. The criticism is not completely ungrounded. I'm not saying it's completely wrong, but reveals on the one side a certain degree of hypocrisy, and undoubtedly on the other shows a profound ignorance of the current state of affairs in terms of harmonization as well as normative convergence in the field of healthcare services in the European Union. And as I hope will become clear at the end of my presentation, there is actually nothing or very little to be feared in terms of potential breaches of common European values and national identities in light of the significant developments, not perceived perhaps, in the field of healthcare at the EU level. Now let's go back for a second and see what the treaty tells us. Article 6 TFEU says protection and improvement of human health falls within the competences, what competences? Supporting competences, so that the action of the institutions in this field cannot supersede the responsibilities of the member states. Now, in other words, no harmonization is in principle possible, and therefore no preemption. And moreover, the management and organization of the healthcare systems belongs to the member states under Article 168, paragraph 7. And I should also remind you that any decision to harmonize social security or social protection requires a unanimous decision by the Council under Article 21, paragraph 3 TFEU. Thus, it would appear that the regulation of healthcare services cannot be considered an exclusive competence by virtue of preemption, because preemption cannot operate. And therefore, the final result would necessarily be a mixed agreement. But if that is the case, what are the real risks posed by FTAs? And in particular, again, I will focus on the CETA agreement. Well, I would indicate the following. 3. Firstly, the EU and Canada opted for the negative list approach, which means that unless a reservation is explicitly taken up, trade in services is liberalized. Secondly, a complete carve-out from the scope of any of the trade in services is granted to services supplied in the exercise of governmental authority. But what is governmental authority remains to be seen. Thirdly, reservations concerning cross-border trade in services introduced in CETA Annex 1 are subject to standstill and ratchet effects unless expressly mentioned otherwise, where, let me remind you, standstill effectively means that the current status of liberalization is locked in, and ratchet means that any future liberalization measure cannot be taken back. By contrast, what is included in Annex 2 is subject only to the standstill effects and not ratchet, therefore allowing for future changes. Now, let's look at what the CETA agreement says on cross-border healthcare services. Pursuant to Chapter 9, we have definition of cross-border supply of services, which means the supply of a service A from the territory of a party into the territory of the other party, from a professional residing in France to a consumer based in Canada, or B, in the territory of a party to the service consumer of the other party, i.e. in France from a consumer based in Canada, but does not, says the provision, include the supply of a service in the territory of a party by a person of the other party, which means basically a service provided in France by a professional based in Canada. This is excluded. The agreement covers in particular measures affecting the production, distribution, marketing, sale, and delivery of service. B, the purchase of, use of, or payment for a service. And finally, the access to and use of, in connection with the supply of a service, services which are required to be offered to the public generally. By contrast, services supplied in the exercise, as I was saying, of governmental authority are expressly excluded from the scope of application of the agreement. The EU introduces reservations that are applied to the EU as a whole, and each member state of the EU was given the possibility to introduce individual reservations. I will come back to this in just a second. Now, if we look at the EU, we have a general horizontal reservation concerning public services and a health sector-specific reservation covering publicly and privately funded health services. In Annex 2, instead, only standstill, the EU reserves the right to restrict market access for investments in services considered as public utilities at a national or local level. As I said, national complementary reservations are foreseen. Now, I will, of course, not go into the detail of every single reservation included by member states. Let me just say that they're pretty limited. Austria introduces a reservation, for instance, only for ambulances services, Germany for hospitals, Belgium for ambulances and residential services other than hospitals, and Bulgaria, together with other member states like the Czech Republic or Malta, for hospital services, ambulance, and residential services. So they're pretty close. They're just putting more a focus on certain services than others. Nothing surprising, as we will see in just a second. Because now that the general framework has been outlined, it is perhaps time to verify to what extent CETA and the rules I just considered is capable of impinging upon the managing of publicly funded hospitals and clinics via liberalization of healthcare services, which appears today to be the main problem or concern. Now, to that effect, again, it is worthwhile looking at the current stage of European integration. Why? Because the degree of legal and economic impermeability of the national healthcare systems not only depends on the specific reservations included and formulated by the single member states, but also on the position adopted by the Union in relation to aspects which have de facto been harmonized. So, firstly, if we look at the criterion used in CETA, according to which services supplied in the, and I quote, in the exercise of governmental authority means any service that is not supplied on a commercial basis or in competition with one or more service suppliers. This is absolutely coherent with the case law of the Court of Justice concerning the applicability of internal market rules and competition law. Suffice it here to recall, well, it has already been recalled, the Almark judgment, where the court stated that state aid rules would not find application only insofar as the recipient undertaking has public service obligations which are clearly defined. But at the same time, if we look at the notion of service of general interest within the EU legal order, we observe that it is increasingly restrictive. If we look at Article 56, TFEU, freedom to provide and receive services, here the court indicated that the public nature of the service can be inferred from the presence of the following elements: universality, continuity, satisfaction of public interest requirements, regulation and supervision by the public authorities. But we also know that regardless of what Article 168, paragraph 7 says, regardless of what Article 21, paragraph 3 says, regardless of what Article 6 TFEU says, there has been harmonization. There has been harmonization of social security, coordination, not harmonization, of social security, regulation, what is now Regulation A83 2004, but we go back to the first version and we find out it was adopted in 1971. But mostly we see the adoption of Directive 24 of 2001 on patient rights in cross-border situation. And this is a directive that was adopted based on Articles 114, approximation of laws, and 168. So combining the shared competences with the complementary or supportive competences. Now, what this directive does, and this is very important for our purposes, is basically it is concerned with the responsibilities of the member states, those of affiliation and those of treatment, and the procedures they can envisage to guarantee both financial stability when patients receive medical care abroad, and what the court is actually doing here is bringing healthcare services within the domain of the internal market, and therefore being able to apply the logics of the internal market to the delivery of healthcare services. What the directive ultimately does is harmonize the conditions under which the member states cannot refuse authorization and reimbursement for medical treatment received abroad. All this is possible because since 2006, the health ministers have accepted, of the member states, have accepted in a European Council, they have accepted that the healthcare systems of the member states share common values. And these values are universality, access to good quality healthcare, equity, and solidarity. Mutual trust is possible, in other words. Now, this partial harmonization, it goes without saying, has impacted tremendously on the organization and functioning of the healthcare systems in the member states. Both those who follow a beverage model, where, just let me remind you, the funding of healthcare system essentially relies on general taxation. The services are predominantly or exclusively provided in hospitals and clinics, which are owned by the government, and where the principle of universal access invariably postulates waiting lists. But it also applies, and here I can mention Italy, Spain, the UK, which follow this model. And then we have the Bismarck model, where instead you have insurances or sickness funds, which, if you prefer, which are largely financed by the employer and the employee, and hospital and clinics are private in nature. So over time, these models, actually, what we see is an hybridization of these models. There is no pure model, if there ever was. And this process has enormously accelerated with the economic crisis. And let me just remind you of the communication of 2014 of the Commission on effective, accessible, and resilient health systems. And here, the Commission supported the adoption by the member states of a sound, risk adjustment methods to avoid patient selection and discrimination, and to ensure that funding is adjusted to the need. Now, the need to coordinate national economic policies also in the field of healthcare, we find now in the European semester. So what we have at the end of the year is a number of recommendations by the Council to a number of member states on how they should manage and govern their healthcare system in an efficient and effective way. Very far away from a parallel competence, at least in my understanding of the word. So it is only in very limited cases that the member states can invoke their special responsibility and say, this cannot be done. So at the end, the healthcare systems are, to a certain extent, and to a large extent, I should say, conditioned by internal market rules, and yet we still find the principle whereby they are responsible. And we also know that public order issues or public health issues can always be invoked. It's a matter of proportionality, though, in that case, as I fear will be in the future through these FTAs, in any case. So the current concerns express the reality that might have been, perhaps 15 years ago, after the Cole judgment of 1998, where the Court of Justice effectively declared that healthcare services are services within the meaning of Article 56. Now, two examples taken from the case law and then final conclusion. There are two cases that are quite revealing of the extent to which the member states have long lost their prerogatives in these sectors. And here again, I'm only talking of this scenario, the movement of the service or of one consumer. In Watts of 2006, concerning the reimbursement claim from the NHS, from Mrs. Watts, for her hip replacement she had undergone in France, the court rejected the argument put forward by the UK government that reimbursement without a priori authorization is incompatible with the system of waiting lists. This could be a possible objection. My system has waiting lists, therefore I cannot accept more free circulation of healthcare services. But the Luxembourg court held that, and I quote, in order to be entitled to refuse to grant the authorization to receive medical treatment abroad, on the ground that there is a waiting list for hospital treatment, the competent institution is required to establish that the time does not exceed the period which is acceptable on the basis of an objective medical assessment of the clinical needs of the person concerned in the light of all the factors characterizing his medical condition. Second case, even more revealing, Elkinov case. And here we have the court went so far as to declare that, provided the treatment received is also offered in the National Healthcare Service, provided that it cannot be offered let's say, in a reasonable time frame, taking into consideration the situation of the patient, the authorization, and I quote, cannot be refused if, where the list of benefits for which the national legislation provides does not expressly and precisely specify the treatment method applied, but defines types of treatment reimbursed by the competent institution, it is established, applying the usual principles of interpretation and on the basis of objective and non-discriminatory criteria, taking into consideration all the relevant medical factors, that the treatment method in question corresponds to types of treatment included in that list as demonstrated. Therefore, this means that if you have, as a state, a very general categories of healthcare services, the Court of Justice will look in and try to single out whether a given service has actually been excluded, expressly excluded. If not, there's some kind of presumption that it will be included. Now, in light of all this, it is possible, I think, to scale back the criticism addressed to FTAs like CETA in relation to access to medical treatment. Indeed, there is a great potential for the development for instance, telemedicine, with important cost savings on the one side, and, in my view, no blatant violation of pivotal national or European values. The process of dismantling traditional solid national healthcare systems has started some time ago, and the need to turn to sound management of public resources, which inevitably entails the involvement of private actors, is a must, and not only in times of crisis. Thank you very much for your attention.
Thank you very much, Giacomo, for this speech on really also on the technicalities of healthcare and free movement of persons. Now we have some time to receive questions. We have had a large overview on different topics. Sure. First one is from.
Now, is it good manners to ask a critical question or to one of the other speakers in the panel? I'm not sure. May I? I mean, we've been knowing each other for. I enjoy what you said, but I wonder whether you did not push the argument a little bit too much. Well, let's say that I disagree. Because you take as examples of the fact that health is subject to the internal market, very specific kind of case law where the court clearly emphasized the individual right dimension. The court in what speaks about the right of the patient, not the recipient of service, to go to another. So I think that, and again, the directive in itself is nice, but it has a very limited impact. I'm a little bit more surprised that you did not actually mention the service directive, which instead is exactly the opposite model, whereby health is excluded from the service directive. And if you look at the recent case of the court, exactly on the service directive, and in particular the Belgian case on the old house people, the house for the retired, I think it's quite clearly the opposite. That is to say, the organization of health is still main responsibility of the member state. So, in my view, the picture is a little bit more complicated, but I don't know what you think.
Thank you, Andrea, for the question. It's, as often happens, it's a matter of perspective. You focus on the individual right, which unfortunately it is not there because Article 35 of the Charter has not been valued enough to affirm that you're actually looking at a fundamental right and therefore a value. You are looking at a service recipient. On the other hand, when I talk about perspective, I'm more interested, quoting Watts, in indicating that even in a system such as the UK, where you could actually argue that that kind of system belongs to the national identity, there is no space for national identity. It has never been invoked. It has never been, the question has never been posed before the court. I will agree to that. But there were many occasions such as this. Waiting lists is a very important deal for the UK, and it is part of the tradition. I quoted Italy as well in the group of beverage countries. But we have, over the past 30 years, done them all. We changed them 3 times, so it's very difficult to affirm it's a national identity. What my point was, and I didn't have time to mention other very important judgments like Müller-Fouret, for instance, where the problem is, well, yes, if you were, though, a member of the Belgian national healthcare system, I don't know whether you would disagree this much in the sense that that judgment has had huge repercussions, internal repercussions, also in terms of financement. So, and I see no major opposition to this trend. And so I see no actual possibility to say, oh no, we have accepted that this is the trend within the EU, but if we talk about relations with third countries, then that's a matter of values. That's my point today is, it is very difficult in these cases to make an argument based on values to restrict the possibility to receive services across the Atlantic. But I guess we agree to disagree. It's a matter of perspective.
Thank you. There's a question here. Want to come here? Sorry, the acoustic of this.
Thank you very much for these very interesting presentations. I would like to raise a question for Professor Mondrieux. Essentially, the TTIP approach is based upon a TRIPS plus approach. You know, most of these rules are in the TRIPS, and then they add on some additional ones. And in the literature, we had an increasing debate about whether this is the right approach to take in a transatlantic agreement. For example, the TTIP draft does not address parallel importation. The question of exhaustion of rights is not addressed. So probably the US and the EU can continue to operate on secluding markets in terms of parallel of trade. There is no limitations discussed on thresholds on the maximum protection you may grant. This has been a criticism from a competition policy perspective. Thirdly, there is no discussion about how this interfaces with the different antitrust systems in the EU and the United States. So for a new comprehensive agreement between the most advanced nations and countries and leaders in the IP, is a TRIPS plus approach, is that good enough, or does it not, should one not go into the relationship to antitrust rules to address the ceiling problem and to address also the parallel trade problem?
Thank you, Professor Cottier, for this fascinating question. I must admit that I largely share your approach, at least on the two first points you raised. I did not detail, since we are really in a very broad context where, by the way, the US did not expose itself so much. I did not raise so much the aspect of the TRIPS plus aspect. The question of antitrust, of enforcement and of antitrust remains an open question. The chapter has been treated as an intellectual property chapter. In the TTIP, progressive and shaking construction up to its temporary or final stop, there is a gap there. Should this gap be completed? Should new treaties with the US, between the EU and the US, include this second very important element? Question mark. Should treaties with other OECD partners be based on the sole work that has been done up to now on the IP chapter of the TTIP, or be completed by the Article 40 plus of the TRIPS agreement? There is no single doubt that this is a major question mark, and I think that it's very important that we also raise this question, to which, of course, no reply can be given today.
Thank you. Is there any other question? Yes, please.
So, a question for Professor Biondi. I think one of the interesting things about the European Union is that it managed to overcome the big debate between left and right in European economies about the state, the role of the state. And many countries simply accepted the rules on state aid as part of the framework of the EU. Do you see any change in that in the Brexit process so far? Do you see any way in which you quoted Greg Clark, and I think Jeremy Corbyn? Did you quote Greg Clark and Jeremy Corbyn? What's your sense of the political sensitivity of this issue now?
Now, I think that gradually, and that's also interesting to see that just 2 weeks ago we had an official statement from the government accepting the necessity for some form of state control, and at the same time, especially coming from the Shadow Chancellor MacDonald, there's a gradual acceptance that that's not actually a bad idea. I think that what we've seen here is that on the one side, it's an acknowledgement that, especially for the British economy, that's not the issue, because in reality, if you think about that, the UK never had, 1 or 2 negative decisions from the European Commission. 99% of the times, they're all approved by the European Commission. Huge success rate. Action recovery is non-existent. So in reality, it's an economy which is, as I said before, been very based on general economic measures, probably would still not be caught by state aid control. What I think also is emerging, and then we don't have the time to go through that, but especially with the emphasis on fiscal aid, there's an acknowledgement from the other side that in reality, transparency of fiscal policies, I think is conducive for a modern democracy. So, because one of the questions, again, between friends, despite the fact that the class economic policy, UK government's policy would probably fall outside the scope of state aid law, what we got in the UK is a massive and a hugely acrobatic series of tax measures, which instead I think are quite problematic from the point of view of state aid control. So obviously the idea that the quality also means that the benefits of the market should also be shared equally. I think that this is going to be probably a massive, huge emphasis. That is to say, fair taxation for corporations, but at the same time, how to use, for instance, state aid to promote small business. Can you just grant tax benefit to small business, which is part of, for instance, of the Labour Manifesto? And again, probably state aid would simply allow it as a general measure. So I think that you see a little bit of gradual acceptance that in reality it's better to have some forms of control on public spending than simply leave it entirely to the market.
Okay. Thank you. Yes. Professor Attila Tanzi is, everybody knows him, professor of international law here in Bologna.
Just because I'm from Bologna University. Now, just a very, very short question, rather a curiosity, mainly to Professor Mandaria, but not exclusively. I suppose, like everyone else, has been very much drawn into looking at the negotiations from the substantive law point within the European Union member states on the one hand and between the European Union and its counterparts. But I noticed from your presentation that there has been much attention drawn to the attitude by third states. On the one hand, attention to the need for conformity or consistency with third agreements and to cooperation with third countries. I have no idea what role, if any, the technical clauses on most favored nation clause played out in these negotiations, and what was the attitude about it. Thank you.
The question is maybe addressed to all of us, but for the part of intellectual property, certainly the TRIPS agreement, the minimum standards of the TRIPS agreement are minimum standards. The fact that two partners negotiate and establish an area with higher standards does not force the third countries to reach these higher standards. It is sure that the US and the EU have a common objective, which was also mentioned in this very context by Professor Cottier. They have this common objective to further raise the standards of the TRIPS agreement and manage that the minimum standard, therefore of the TRIPS agreement for most favored nation and so on, be as such raised and reach higher standards. This is basically what renders the IP chapter easier between the EU and the US, or between the EU and nowadays Japan, and nowadays Republic of Korea, and very, very soon with China, which is becoming the first patent power of the world, the first IP power of the world. For sure, this means that the agenda shared between the US and the EU has a strong effect not a strong effect at TRIPS, at the WTO, but a strong practical effect by changing the shape of the global negotiations at the WTO. That would be my simple, modest point of view for the part of the WTO agreement I work upon. But I leave the floor to my colleagues, of course, if they want so.
Well, I just have a reflection that I'm actually for healthcare services and the problems they may pose to the organization of healthcare, the healthcare system. It's a competitive world out there, but only very few states can actually have a system, a healthcare system. So that would be a prerequisite, of course, to have a healthcare system. But there are something like between 40 and 50 states in the world that can actually claim to have a healthcare system, which is not out-of-pocket money. So this would inevitably condition the negotiations on that chapter for third countries, of course. I would find it difficult because of a factual situation, the very limited number of states that can actually claim to have a healthcare system, working healthcare system.
You're asking me the question as a third country representative, I guess. Well, again, just to see the point that why the Brexit negotiation is such a sticky point, because, I mean, how do you square the circle? You want to ensure, equal level field in the area of taxation, environmental protection, labor standards, public procurement, and then what are you going? And then within the idea that you experience 40 years of access to the market, to the internal market, right? Which is obviously, most favored nation, from the perspective of the internal market, as we know, doesn't make any sense. So how can you simply, revert to this kind of clauses in the new agreement, whereby the business, companies, individuals, they are just used to a very different kind of legal regime. So, it seems to me that, again, I'm not trying to make any kind of political statement about Brexit, because, we even receive sort of threats and things like that usually. But, it's really technically a huge enterprise, because it's really about reinstating certain kind of concept that we simply did not use for the last 44 years.
Thank you. Any other question? Or comments?
Just encouraged to make a comment on the MFN clause. I think it is important to distinguish two configurations. One is the Euro extension of MFN, and that's a typical case in intellectual property, because the TRIPS agreement requires countries to extend any level of protection they grant to all other countries. So if the US and the EU engage in high levels of protection, they are legally bound to extend that level of protection to all the other countries alike here. That's why you have to consider the third country effect, but that's not the problem for these two entities normally. The other constellation is that normally under a free trade agreement, you do not grant MFN. That's the whole point of Article 5 exception in services and Article 24 in goods. But to the extent that you go into regulatory affairs, you may modify your own domestic regulation in accordance with the agreement, and then you apply that regulatory system to all people in the same way. So you lift a boat with the water, although there is no legal obligation to do that here. And that probably could be one of the challenges in the healthcare system, because the way you described it, it reflects a very high level of integration, basically, in the EU, you know, from patients' rights and the systems gradually. But if you want to apply this to any other country, or even countries running a national health service, well, like Canada, it's going to cause a lot of difficult questions here. So you probably can't use a one solution to all approach here in these, and so you have to differentiate and you make sure MFN doesn't apply in these areas here. And I think the same is also true with subsidies. Clearly, I mean, this must be a safeguarded system which only applies within the free trade agreement here. But the question I simply would have here, if I'm curious about your who can challenge subsidy measures. What about the constellation when let's say a subsidy within the European Union is going to be cleared, let's say in automotive sector, and then the UK would challenge the measure? Could they do that, or how's that? I mean, that's really raising very difficult issues of double jurisdictions, and how do you comment on that?
Because obviously, technically, you could probably argue that in terms of business, I mean, you can still, you know, a UK firm can still try to challenge a subsidy anyway, because, you know, they will still have the right to action against the Commission decision. That's still, because, you know, basically European law says any interested parties, right? So probably you can still preserve the individual right, sort of, you know, the specific right to, or perhaps they can also act, you made me think, they can simply send a complaint to the European Commission, because once again, nationality is not an issue, any interested parties, right? So that could be probably, sorry, I'm just thinking out loud, probably be preserved in terms of individual companies. Then obviously, if we have a lack of any kind of agreement, we will fall back on WTO rules. So it will be just for the government and then final scenario, the new agreement, exactly, we are still just completely, we still don't know. I mean, what I was trying to just come up, just sort of personal remarks, because at the moment, as I said, apart from this official letter from the government, which dates back 2 or 3 weeks ago, that simply says, we are going to have rules, don't worry, there's nothing else. So, yeah, I know. It's considering that it has to be done, I mean, from in a few months' time, we become third countries anyway, because the transition measure, even if it's going to be accepted that it's going to take till December 2020, the UK technically becomes a third country on the 19th of March 2019. So after that, I don't know if you need any professors of European law in Bologna, but
just 2 quick answers from this side.
Yeah. Just one quick comment, rebounding on what Professor Cottier mentioned. Of course, the MFN would apply to any country that would trade with the EU and the US through an agreement. That means to most countries. And as such, this is a way for the US and the EU, and this is where there is an alliance, despite a few technical discrepancies, well, several technical discrepancies. There is an alliance for reproposing in another format and through the back door, in a way or another, many elements of the ACTA, by making it between themselves, the two partners, force the rest of the world trading with them to further work on this way, or trading without the EU and the US, which is of course a big risk, but not an impossible risk at a stage where a third power, China, is emerging as a key trade partner on its own.
Yes, very briefly, sorry. Just to make sure that my message was clear enough. I wasn't arguing that it is easy to do or that there is no regulatory issue. Of course there is. There is in Europe. There are many problems, regulatory problems. What my argument was is that there is I see no actual possibility to object by invoking values. Because if there were those values, they would have been raised in Europe under the stress that the healthcare systems have had because of the convergence and harmonization. That was my only argument. Because values and rights, my idea was let's analyze and verify whether there is a serious risk of objecting because of infringement of fundamental rights or values. So I wasn't tackling the regulatory problem, and that's a huge problem, of course.
Thank you for this debate. As you from the speech were quite interesting, and the debate proved that they were able to raise important issues. I just want to recall you that our workshop will start again. The last session of this workshop will start again tomorrow morning at 9 here in this Sala delle Armi. And therefore, I thank you for your attention, and I see you tomorrow. Thank you.